Ngamahi nui, kia koutou e hui mai nei. Welcome to this workshop of the Environmental Science and Policy Committee. We'd just like to start with karakia.
Kia ora, e koutou katoa. E korongo ake a ki te tangi a te manu nei, mā tui a. Tui a ki ronga, tui a ki raro, tui a ki roto, tui a ki wā. Tui a i te here tangata ki whakarongo ki te pō, ki te ao. Tui te mukataka te Hawaii ki nui, Hawaii ki roa, Hawaii ki pamamao. Whānau haere mai te toki haumi e hui e.
Thank you, Edward. Welcome everybody. We have in the room Councillor Ware, Scott, Chair Robertson, Councillor Noon, Councillor Somerville and Councillor Kelleher, and I believe Councillor Malcolm is in the 40. He'll be here in a minute. I believe on screen we have Councillor Laws.
Correct.
And I see Councillor Forbes has arrived on screen as well. Marina, Alexa. We also have we have in the room, we have Anita and Fleur at the top of the table. And we have Felicity from Wynn Williams, who's involved later on, and other two Toms and Joe. That's all good. And I believe Dr. Palmer's on the screen as well. So do we have any apologies?
Kate for late.
Apology for Kate for lateness. Cheers for Kate. Any declarations of interest? Okay, so the agenda's been pretty well set up pretty clearly. So I think at this stage I'll just pass to Fleur to start a workshop off. Thank you.
Thanks. Tēnā koutou katoa. So today's the first session that we've got in May. We'll have another session in a couple of weeks' time. So I'll just take you briefly through what we're going to cover today and then also what we're going to cover next week or in 2 weeks' time, just so that you know kind of what to expect from today. You might have noticed we've taken a slightly different approach this time, where we've sent out perhaps more fulsome papers than usual, and we'll be working through those papers rather than a slide pack today. So today's session will cover 5 areas. The first is public excluded, which we'll talk to when the time comes. But then we'll move into a public workshop where I'll walk through the draft revised work programme for delivering the land and water plan for notification by 31st of October. And then we're hoping to break for morning tea time. Next up, Felicity will lead you through an overview of the regional policy statement decisions and the analysis that the team's done on implications for the land and water regional plan and the changes that we're looking to make as a result of the regional policy statement decisions. After lunch, Matthew McCallum-Clark will take you through the clause 3 feedback we received on the forestry provisions. So if you recall, the Forest Owners Association didn't receive the email that we sent seeking the clause 3 feedback. So we held over going through those forestry provisions until we received that feedback. So the paper that we provides an indication of the changes proposed, and you will have also received the clause submissions in the separately. And then finally, Felicity is going to present advice on the overall approach to setting duration for resource consents in the plan. This is something we've talked about before, but we wanted to get some specific direction on it because the regulatory basis for the previous position just has changed now that the Natural and Built Environments Act was repealed last year. So we'll go through that as well. So that's what we're covering today. Any questions on that before I just move quickly to what we're doing next time? All good? All right. So at the next session, we're kind of going to be going into some of more of the detail that will be touched on today in Felicity's regional policy statement paper. So more of the specific areas that we need guidance on due to changes both in government policy and the changes in the RPS. So the topics we're covering will be environmental outcomes. So in particular, how they should be adjusted to fit with the RPS visions and just a sense check on how achievable they are. How to manage land use changes that cause increased loads and contaminants. So managing intensification. What we're going to do about intensive winter grazing, stock exclusion and freshwater farm plans, now that the government's looking to remove those and change them up. And then also what to do in the debate about managing wetlands. So that's one topic we'll talk briefly about today. All right, any questions before we move to the first presentation?
No, that's all good. Thank you very much. And just recognise Aminui Karen, welcome. One didn't give me a full rundown on the use of the microphone before we started. The next one. So the next area is around the updated work program. So we can just I'll just go back for a bit of discussion around that prior to going for a smoker break. Thank you.
Thanks, Lloyd. So if you're following along, it's agenda item 3, and it's a revised land and water work program origin notification. Really, this paper just sets out what we've proposed as the work program from here through till October, just as a result of council's request. So our intention is to provide this through to the council meeting on the 22nd of May. Yeah, but it's relatively self-explanatory, but I will just quickly run through, I guess, the key points. So we're currently working, just if you look down to the table, working through some meetings with clause 3 parties, and also today considering the forestry feedback as discussed already. Another key task was around the assessment of the regional policy statement. So we've reviewed the decisions and looked at what changes to provisions we had. So we'll be going through that later today. And then we've just got to actually update the wording to reflect those changes. The third kind of new task was this report to the minister, which you approved last week. Was that last week? Yeah. And have been sent off this morning, I believe. So that's now complete. In the council meeting associated with that. Moving down, the next thing is today's workshop briefing. So that's pretty self-explanatory. I won't go through that. And then the following one in 2 weeks' time. Yeah, there's just a bit more drafting of some of the things. So yeah, we've just pulled out the 3 key areas for that. There's also, we're kind of constantly refining drafting as we go. As Michelle said, they're doing a legal review. That's they have actually started already with some of the chapters that are kind of in more of a finalised state. And that will go through till towards the end of June. What we'd like to do is have a workshop or briefing on the whole plan before we send it out for clause 4 consultation. That's just so that you've got a really clear idea of where things are landing, because that's essentially kind of the final draft, which we then share with iwi authorities through the clause 4A consultation. Alongside this, there's a bunch of work happening on the Section 32 report, but I haven't kind of got that in this report, but it is definitely happening, and that will all be ready for a legal review in July. So the idea, July and August, the idea being it's kind of at the time that the clause 4A consultation's happening, just to make sure we've ticked off all the boxes around things, especially things like where we've been more or less stringent than national direction and stuff like that. It kind of goes through, final formatting and finalising the plan and the report. We're hoping to send it to you by the 17th of September, which happens to be my son's birthday. So I'll be aiming for that too. And then having a workshop briefing on the section 32. So we want to send you both documents together so you can see them. So I think you kind of need to see them both, but we'll have one workshop focused on the section 32 report and then one focused on the final wording. And so that's September and October is what we're planning before we're finally ready for the 23rd of October council meeting.
Awesome.
Any questions?
Thank you, Phil. Brian?
How much buffer have you got in there at an appropriate time to cover unforeseens, bearing in mind that this is not the first program I've seen for delivering this plan?
There's not a lot of spare time. We will be working to get it done.
Well, I think my point is that, well, there should be some buffer in there because something will happen and we'll have another, report to council saying, oh, we need another delay. So you might find, for example, that certain sections need to be going faster than allowed for, not on the basis that we spread it out until the 23rd of October, but in the fact that, yes, we've got an allowance in there for 20% unforeseen or something like this, so that if something comes in, we can allow for it.
So the time that we did have, we've used for the clause 3, so we're continuing to meet with those clause 3 parties to refine. It's kind of this time now, but once we get that done and get a new draft, then we go back into the statutory process. There just isn't a lot of fat in there. It's just the reality of how long it takes.
Thank you. Kate?
Can I just understand who you're meeting clause 3, because that's a fairly wide bunch of people, and with all respect, I think one of the biggest issues some of us have had is that we find and hear real concerns in the clause 3 responses and haven't felt that they have been well listened to date. And I'm just checking what that means, because it may overcome a lot of my issues or it may not.
Sure. So I was expecting that this might come up, so I have just checked in this morning to make sure I've got all the
Can I
parties.
just check?
Yeah.
Sorry, this is now public, isn't it? You think?
Yes. Yeah. So the clause 3 parties that we've met with is Environment Southland on some cross-boundary issues. We've met with Horticulture New Zealand on managing liquid agricultural waste. We've met with Kaitahu to work on the strategic direction, so the integrated management and land and freshwater chapters. We've met with Dunedin City Council on the wastewater, stormwater and flows chapters. And I'm just in the process of organising a meeting with Dairy NZ, Beef and Lamb and Federated Farmers on intensive winter grazing, freshwater farm plans and stock exclusion. So that they just got it to me this morning, so I haven't actually organised that yet, but that is underway.
So in essence, the clause 3 parties that reach out to us, we take up their offer of meeting.
So that you pick the issues that you discussed with them consistent with that response sheet that we got, or are you looking at other things? And I'm going to give one that some of us will know from last week's sediment traps, where when we went to Peter Palmer's, there was a concern that their submission or their response on the clause 3 feedback hadn't been taken up. I mean, are you up and willing to keep on upping those numbers or those other issues?
So we're responding to them. It's led by clause 3 parties. If they approach us, we meet with them and discuss the topics they want to refine.
Okay, because those ones that you mentioned are the ones that the government's really looking at, which I presume makes life really tough for writing a plan around something that may not be there. Yeah, okay.
So who was the number 2 that you did? It was Environment Southland.
Port New Zealand.
Port New Zealand.
Yeah. I've got another question, but go around the table first.
Oh, I've got Elliot. Question. Sorry, Andrew then.
probably a question for Fleur or Anita. Just looking at the schedule and the clause 4 consultation between 15th of July and 9th of August is then incorporated into the draft land order plan and section 32 report 17th of September. Is there any opportunity between the end of the clause 4 consultation and the 17th of September for governance to understand where that's landed in terms of the feedback through clause 4 consultation? It's up to your discretion with some of that. But
Yeah, good question. I suppose it probably depends what you might have in mind in terms of, like, we can certainly kind of give a summary, probably by email, but if you wanted something more in depth, might be.
Any changes?
well, I suppose it was sort of a no surprises approach, sort of understanding, the outcomes that have influence, so or need to be incorporated, or make to be incorporated into the draft plan that are changes to where it was previously before clause 4. So that's what I'll be looking for.
Yes,
Yeah.
question is, are you looking for a briefing? Just some direction on what you're looking for, and then we can build it in, really.
I would think at least a briefing, yes.
Yeah, we'll factor it in.
Thank you.
Somewhere.
Thank you, Andrew. Karen?
I've made some comments in January about objectives, policies and rules, and they should be able to be read consistently forwards and backwards, as in they should, a policy should have an objective and the rule should have a policy, and we should understand where they're trying to go for. And there were some sections that had policies that didn't have objectives. So, and the problem with that is, at what point does that go back out to clause 3 if they're being added in after the clause 3? Because they could change the tone quite a lot when they are added in, or I presume they're being added in because there's signs of that happening. I've been told that that is happening.
Yeah, so I mean, that is the kind of thing that the legal review is picking up, as well as just kind of more a chance to read the document. In terms of going back to clause 3 parties, it's not really an iterative process in terms of we can't kind of keep going out with drafts. So I'm expecting,
Okay, so the problem is that if you've got an objective missing and you add one in, that is quite a substantial change potentially to something and could have an effect on how something is, because it may clarify what the outcome is or not, or a rule may be taken out. And that's the problem, is I appreciate it's not iterative, but we went out potentially early in order, because of the timeframes, and I'm just,
So I mean, that's the kind of thing I would expect to receive through formal submissions. Like, there is still a lot of chances for people to have a say about, if they don't like the new objective. I don't know if you want to.
as an informal process and going to, okay. The section 32 report, we're not going to, when do we get, it looks like we get that very, very late in the piece. And the problem with the section 32 report, not problem, sorry. The thing about the section 32 report is it is the last check and balance that what we are suggesting is efficient and effective. And if we find out late in the piece that something isn't efficient or isn't effective or may have some unintended consequences, at what point do we get to see that balance and what the responses are? Or is that something we're just going to do again, battling in a litigious way?
So there's a day set aside for the section 32. The challenge with the section 32 is it can't be completed until you've done your clause 4A consultation. But you're right, that is what it does. So there is time between the section 32 and the final workshop to adjust if we need to. In Southland, when we notified the plan, there were 2 or 3 rules which the section 32 clearly identified were not the most efficient or the most effective, but they were the most politically available rules, and so they went out. So the section 32 can be as transparent as you need it to be.
And how long did the Southland plan take to get through?
Less than 2 years to get from notified to decisions, but the appeals have been a long time.
Yeah, sorry, it's broad. It sets up a really litigious platform. And that's where I don't think we've been realistic.
So every plan, the nature of the planning frame.
Thanks, Kate. You've got, Alex got a question?
Yeah, just wanted to follow up with what Andrew was asking about before around, I guess, coming to us after clause 4 consultation. Was that in addition to the October 9th? Were you thinking something ahead of that, or Andrew?
Yeah, we'd be looking to fit it in between after the 9th of August and before the 17th of September in there somewhere.
Because presumably the 9th of October session would cover that stuff, or do we need a
I think the
specific?
keeping is a sense check before we get to the 9th. The 9th should be rats and mice really, and so something ahead of that just to ensure there's nothing significant or substantive.
Thanks.
Do we have any other questions? Brian?
Yeah, just going back to my earlier point about the timing
Brian.
and so forth. Is there any allowance in there, just thinking of in terms of central government and any changes, whether it's RMA or policy statement, national directive, and the impact on that and the timing implications?
The short answer is no. If council decides, if something comes up, we will bring it to you and you can make a decision about what to do.
Yeah, but that's my concern to the CE, because I was told no, but it was only a month or 6 weeks ago we were told we could achieve the end of June objective, and I'm assuming that some of the timelines, if they'd been replicated in here, there would be some buffer to enable, if we're in a situation where central government says there's this change, or like I intimated, does that mean we just go into a spin again and kick the ball down the road?
So the additional time taken from 30 June has been filled with proper assessment of the RPS decision and more in-depth assessment and engagement in the clause 3 process. To meet 30 June, we wouldn't have done those 2 steps. We would have finished the process and notified the plan. So all of that additional time has been taken up undertaking those 2 exercises that council instructed us to, and ensuring we still meet the statutory requirements in terms of clause 4 as well. So it continues to be a tight program. We continue to be confident we can meet it, depending on direction we receive from ministry officials. We will need to assess that and bring it back to the table for council to consider it and any impact that it may have. But the program is tight. We are confident we can meet 31 October. There is no buffer because we have fully allocated that additional time that was provided in the direction we received when that date shifted from 30 June to 31 October.
And just an example, this happened through Plan Change 8. So you might recall the intensive intergrazing, we had our own provisions in the plan. Then the legislation changed. ORC lodged a submission to withdraw the provisions from the plan in reliance on the national regulations. So there are different mechanisms to respond.
Okay, thank you.
Thank you. I'm just going to go to Kevin and then Kate.
Right, I'm finding it very difficult that we are now questioning timeframes. The timeframes were based on a council resolution by 7 councillors that voted to go for the 31st of October. To now be questioning those timeframes, so I would ask the CE, is he now working to those timeframes that council has so resolved that he must adhere to?
Yes.
Thank you.
Thank you, Kevin. Kate?
A technical one, and it's going to come up in discussion next week when it's things like intensive winter grazing, because we keep on talking about something that I think definition has changed. And if I go through the draft land and water plan, the definitions, we often rely on stuff we know is going to change. And I'm just wondering at a high level how we're anticipating with those definitions. Are we going to rely on things that we know we think will change, or are we going to put our own definitions in? Because it's really important when it comes to things like setbacks, what that means.
Yeah, part of the conversation that we want to have with the sector is about which of those might be changing and which ones we feel like Otago needs to be managing. And so, yeah, I guess we had taken the approach where we didn't replicate things that were in the national regulations, but we're kind of looking at whether that approach is still the right approach now. And so that's part of that conversation.
In an
So-
ideal world, would have an agreed approach between us and the primary sector. That's what we're looking to have something in the plan in terms of freshwater farm plans, intensive winter grazing, and stock exclusion that all four of those parties think is appropriate. That's the aim.
I think that question will perhaps come up on the 28th when we're discussing those sort of.
Yeah, I appreciate it, but we're also dealing with them today, later on when we do setbacks for forestry, and so I wanted to preempt it because it sort of touches on both, so sorry, yeah.
No, I think it's a good point to get made, you know, how we move forward around changes and how we make sure our plan covers all the bases. Do we have any other questions just around the proposed new timeframe? As we said, the council staff have set up a new timeframe to meet the requirements of our last council direction. It's here in the paper. It's you know, it's been a good discussion, and we're ready to have a feedback session or a briefing session following the 4A consultation. But we're also recognising that there is still some time pressures on the plan. It's not like to be able to have a really thorough job. There's not a whole lot of spare time in there, so you know, we need to keep moving forward at each step. So that's really good. And also there's been a bit of a discussion around the Section 32 report when we get to see that and tie it in. So that's pretty much what I've got written down here.
Just make one quick note, sorry, just off the back of Andrew's question about the additional briefing. I've just signed off the paper for noting at the council meeting with this program in it, just so it's formally noted at a council meeting. It doesn't include that briefing, and I'm loath to call it back to add it. So just noting it's not in there, but we'll make sure it's picked up, and we can confirm that at the council meeting next week.
Thank you, Richard. Jerry.
Sorry, I might have missed it, but just in the list of the 4A consultation groups that were to be going back to, was the forestry sector included in that?
So 4A is only with iwi authorities.
Clause 3.
Yeah, the clause 3, the forest industry hasn't asked us to meet about a particular topic, and I suspect after later today they might be more comfortable, but I guess they're running a bit behind the rest of the clause 3 parties. So you know, if there's particular matters,
I think that they're aware this discussion's happening today.
Yeah.
In terms of assessing their clause 3, once there's some direction from the table around the work staff have done, there's still an opportunity for us to go back and have that conversation. They're in regular contact.
Right, okay, thank you.
Thank you. So that's also, I think what we'll do is thank you all very much for your input so far. And we'll just stop for cup of tea and a stretch and reconvene at 11 o'clock. It's 11 o'clock. Thank you. Thank you, everybody, and welcome back. We'll move on to the next item, X. What have we got here? For implicity. Yeah. Proposed, RPS decision. Thank you.
Kia ora koutou. This paper is relatively long. I guess it's a paper of two halves, I suppose. The first part provides an update on the appeals. When this paper was written, the key dates for filing High Court appeals had been reached, and there are 5 High Court appeals on the freshwater parts of the RPS. Those appeals have since been joined by quite a number of parties, 7 or 8 extra parties have joined those appeals. That's basically an interested party who's involved in the hearing process. On the whole, those appeals are, because they are limited to points of law, although they affect a number of provisions, they are very narrow in scope. So for example, you'll see in attachment 1 that all of the freshwater visions have been appealed by Fish and Game, but that is only on the matter of whether they appropriately protect the habitats of trout and salmon, not on the whole content of the visions. And importantly, I suppose to note, there haven't been any appeals on the timeframes, which is helpful for the land and water plan. There also haven't been any appeals on the FMU boundaries, which again is helpful for the land and water plan. The Environment Court appeals we are currently right in the thick of. So the deadline was yesterday. There's always a bit of a lag in appeal notices making their way back to the council. They tend to get fired out by appellants to various different email addresses. Sometimes they go to the lawyers, sometimes they go to generic inboxes at ORC. So there is a little bit of a delay in them all being received, but I think Fleur can provide an update on the numbers.
That's right. So just as of this morning,
I was looking at it last night, there were hardly any.
yeah, no, so we'd received 2 last night, but by this morning, we've now got 10. So, and yeah, as Felicity said, we do expect a few more to probably float in throughout the days. Yeah, once we've actually got all of the appeals, we'll provide some advice about, you know, what provisions are under appeal and how substantive they are.
I've had a look through some of the appeal notices, and because they are merits based, not limited to points of law, in a lot of cases it is submitters seeking that what they were wanting in the original submission, if it wasn't agreed by the panel, they're just continuing to push the same barrow. So a lot of the provisions under appeal and the relief sought by these appellants are not new. It's arguments that we're familiar with.
Thanks.
So the Alice in Wonderland world that we live in, the fact that DCC are appellants on both relating to wastewater, I put the glass, how will that be able to be joined up? Because they won't be the same panels, I presume. Any idea?
So the advice that we've received from the lawyers is that the High Court appeals, despite what Michelle said this morning, their view is that the High Court appeals are likely to be resolved before all of the Environment Court appeals are. And so therefore the Environment Court process will be able to take those into account. And again, as Felicity said, because they're on points of law, the merits shouldn't be coming into it. So, we once we've got all the appeals and we're providing advice to the court about priority and ordering of the appeal, like mediation and that sort of thing, we'll be able to take that into account in terms of the timetable and potentially looking at non-freshwater planning instrument parts that are related to freshwater to be considered, after the High Court appeal. So resolved.
Thank you.
Elliot?
So the second part of this paper is,
You know, plus I think Alex got a
oh,
quick
sorry.
question. just-
No, I was just wondering if there was any overlap or duplication of the environment and High Court appeals, so it's a separate part.
the appeals relate to the provisions. So some provisions are being heard by the High Court and some will be heard by the Environment Court. So from that respect, there isn't overlap in the actual provisions. But some topics like wetlands have provisions in both parts. So there is a relationship between them. And I don't think there's been this situation before. So I'm not sure how the court will deal with that, but I presume that the courts will be pragmatic.
Just
Thank you.
So the second part of this paper is focused on the implications for the land and water plan. There were a few places where the panel's recommendations were different to what the staff had recommended, particularly in terms of part 2 of the RMA and renewable electricity generation. There was also a significant difference in the management of wetlands, which is a whole separate paper coming to you in a couple of weeks, so I haven't discussed that here. There are other places throughout the RPS where there were differences in where maybe the panel didn't accept a particular recommendation, but they weren't considered to be particularly significant in terms of their impact, either because they were provisions that were mostly directing district council plans rather than the land and water plan, or because the amendment overall didn't really change a policy approach that was being taken in the land and water plan. Helpfully, Michelle has outlined the Supreme Court cases that came into the mix with the RPS right at the very end of the process. And I guess it highlights that how you reconcile conflicts between provisions and planning documents is a live issue and continues to be litigated. And I think the difference that you can see in the 2 Supreme Court cases is quite stark. You know, both were considering how to reconcile avoidance policies with protection policies under the coastal policy statement. The Supreme Court membership was the same in both of those cases. It was the same justices, and yet in Port Otago, all of the justices were in agreement on the approach. In the East-West Link, you had 3 different groups of justices taking different approaches. So I think how you reconcile policies we're not at the end of that just yet, I don't think. And I'm aware that there's at least one Environment Court appeal on the integrated management provisions that were really the genesis for that whole discussion in the context of the RPS. So continuing litigation, certainly. In terms of renewable electricity generation, overall the panel accepted the recommendations of the staff reporting officers, but there was.
Can I just, Roy, kind of questions on that? It's interesting that, so you've got the same judges, but is it more built around the fact that the port is an existing activity that still needs to happen and the East-West Link was actually going to be something new?
I think that was one of the important considerations for the courts. And they were looking at slightly different policies because the ports policy in the NZCPS is quite enabling, whereas it's not quite the same situation for the likes of roads, which was the East-West Link situation. So it is really context specific, I think.
Yeah, thank you.
The panel did make some additional amendments to the RPS provisions in relation to renewable electricity generation, mainly to more clearly recognise the contribution of generation to climate change mitigation and reduction of emissions, and to provide for new hydro development in the Clutha and Taieri FMUs. At the same time, there had been clause 3 feedback from a lot of the generators, and although the plan did have a pathway for hydro, it was under the title of non-consumptive takes, which the hydro companies didn't always appreciate or didn't think that they would necessarily always be non-consumptive because some of their takes do actually move the water. So there's been ongoing refinements to the plan provisions to make sure that there is a pathway for hydro, whether it's non-consumptive or whether it is to some degree consumptive, which aligns with the RPS. And we have been looking again at the environmental outcomes for the FMUs, and particularly the one on hydroelectricity generation. It's at the moment limited to existing schemes, but there's obviously now more emphasis in the RPS on enabling new schemes. So just looking at the environmental outcome and whether it needs to be broadened to encompass new schemes.
The one part of that, which I'm sorry, I think I've missed, but can I just understand that it's not just about having new schemes, it's about having a distributed network in climate change. And have we got any guidance on that? Or are you looking at that at all?
What do you mean by the distributed network?
A distributed network is one where you may have smaller for communities to have their individual schemes. I mean, there's lifeline services that can get disrupted with big events, as we saw in Cyclone Gabrielle. And the electricity transmission is not particularly logical or transparent. It's totally non-transparent. But the need for communities to have a distributed system is really clear in the lifelines, and there seems to be no direction on that. And when you're defaulting to big corporates to be the players in this game, it's really hard. And I'm just asking if that distributed networks is in your thinking, because it really concerns me, given climate change and other things.
Yes, it definitely is. The references, the way the approach has been drafted in the Land and Water Plan is that it applies to renewable electricity generation and it doesn't have a qualifier on the scale. So it incorporates those individual small scale schemes as well as your larger ones. And in response to the technical advice on how to better provide for those small scale hydro schemes, there have been changes to the damming and bed provisions to better provide a pathway for them.
Okay, and I'm not just talking about hydro, I'm talking about wind and solar as well.
Yes. Yeah, and I mean, ORC has a more limited role to play in the management of those ones because they are generally mostly a land use under a district plan. For wind, it's really the earthworks to construct the wind farm that would be within the council's functions, and solar again, possibly earthworks if there are any, but largely that one comes down to district plan rules.
And we don't have an overarching planning function to ensure that our communities have a distributed network, which is, I think, where I was thinking in some ways the RPS was starting to go, but hasn't probably gone that far.
Yeah, the provisions in the RPS certainly apply to, they don't differentiate between the regional and district functions in particular, and they do definitely have provisions providing for small scale types of renewable electricity schemes, even, which doesn't differentiate between hydro or anything else. So there definitely is region-wide direction in the RPS, it's just that some of it's not relevant to ORC given its functions.
In fact, from what Gary's said is, Gary's just got a question, but I think we'll just try and have Gary's question, then we'll try and go through your section, the renewable energy section, and then do questions at the end. That's what we talk about. You follow up, Gary.
Well, mine is about renewable energy, so maybe we should.
Wait till the end, and you can be first at the end.
Can be, yeah, that's fine.
Okay. But I think that might work as.
Yes, I was going to ask how best you want to go through this table, whether you want to go through it line by line and just deal with questions as they arise, or whether you just want to launch into questions.
I think you go line by line.
You're talking the big table?
The big table, yeah.
Yeah. I think we might get, well, did you think, so I need to leave line by line would be best?
I think when we've not gone line by line, we've got really mapped up the points ourselves, so.
Yeah, okay, so we can do that. But Gary, did you have a general question around the renewable energy?
Yeah, well, I mean, my question was just around well, the signalling changes. Did I hear you correctly that, as had been previously drafted, Land and Water Plan, renewable energy new schemes would not be going ahead at all?
No.
So now, are we now redrafting that new schemes could be provided?
New schemes have always been provided for in the draft, in the land and water plan. It's just that they were under a framework that was called non-consumptive takes. And so the hydro generators didn't think that they would always be non-consumptive. So we've changed the policy framework now so that it will apply to hydro schemes that are either non-consumptive or they still comply with the flow regime.
Yeah, I think though, like you indicated before, the damming provisions, are they being redrafted? Because if you can't dam an intake, then you would never be able to have an intake.
Yes, so they always provided an exception for for hydro schemes. So you can construct a dam for hydro if it
It's
meets.
only temporary though. Is it temporary or permanent? Because wasn't it highlighted in Ian Walsh's report that that was one of the concerns around the ability to dam an intake permanently? Which to me signalled that had to change.
So the policy direction has always been that allow the placement of new in-stream dams where they are temporary or are renewable electricity generation facilities or for an ecological purpose.
Okay.
Yeah, so it was always the intent to allow for dams of hydro.
Right. Okay, thank you.
Andrew?
Felicity, the WPS feedback emphasised the point that the way the draft plan is written, that Te Manawa Te Wai essentially via MPSFM trumps, excuse the language, trumps the NPS REG or NES REG. So what confidence can you give us that there'll be a balancing provision there? And actually it's a lot about the discussion we had earlier on with the Supreme Court decisions, etc. But can you give us some confidence that that will be the case going forward?
I was a little bit surprised by the commentary in that report because the way that it talks about balancing NPSs wasn't my understanding of the case law. My understanding is that those two NPSs have to be read together, and the more stringent one, or the more directive policy prevails, whichever document it's in. The NPS for renewable electricity generation is clear right at the start that it doesn't apply to the allocation of fresh water. That part is entirely in the NPSFM, where the Te Manawa Te Wai hierarchy comes into play. So it is a case of, and this is discussed actually, that though the relationship between those two NPSs is discussed in the panel's report, and the panel accepts that Te Manawa Te Wai does place a hierarchy of obligations on decision makers, and that you can't override that with a provision in another NPS. You have to find a way to navigate the pathway between those two documents.
So a structured analysis.
Structured analysis,
Okay.
indeed, yes.
Jeez.
I do agree with that, with the report that Te Manawa Te Wai does make it difficult it certainly makes it more of a challenge hydro schemes to get over the bar, but there is provision in the NPSFM for using the effects management hierarchy. It's avoid the loss of river extent or values, except where there's a functional need, which is obviously the case for hydro, and the effects management hierarchy is implemented. So there is a pathway there, and that's what we've tried to provide for in the land and water plan.
Thank you, Felicity. Brian, would you had your finger up for a bit of you?
Yeah, it was just in relation to the district council's management of solar and wind and so forth. And something we haven't talked about is landscape. And I assume that's within the district plans as well. But in our RPS, is there commentary around that as well?
Yes, there's a chapter on natural features and landscapes, and it's predominantly for district plans to manage.
Okay, so district plans. Okay. Thank you.
Given.
Yeah, so a follow-up to that is how do we ensure that that is managed? Because if we're completely altering significant natural landscapes by the putting up these big towers, so how is that managed? How do we ensure that that the TAs are giving effect to that?
So one of the functions that we undertake is submitting on district plans and resource consents to make sure that the RPS is given effect to. So that's generally the way that we manage that. Ideally earlier the better, so through a plan process rather than consent by consent. But that's part of our role.
Yeah, the other thing I would say is that there's obviously a lag time. The district plans have to give effect to the RPS, but there's a lag time for, you know, when an RPS comes into effect for district councils to understand what the changes are and to prepare a plan change and so on and so forth. If a provision in a district plan is not consistent with where the RPS direction is, then the decision makers would have to go up to the RPS and implement that direction.
Thank you.
So we think I've got a clear board for this, so we start going through the
Right.
spreadsheet.
Do you want me to put it up on the screen or are you happy just working through your own?
Consensus?
I'm happy on that screen.
Everybody has it on their own laptop, so as long as we just refer to there's numbers down the side, refer to them as we go.
Yes.
Thanks.
Just for people watching that might not access, can you just pop it up anyway?
Oh,
All right,
good.
sorry.
Page 11 was a tick missing on the last one.
So we're at attachment 2, row 1.
If you go back to the previous chart, though, there's a tick missing in the last. On page 11,
Is there?
I'll go across.
Oh, apologies, yes, the very last entry should be a tick, not a cross. So attachment 2, the big table. It's the first 3 rows are some general themes that came through the RPS decisions that apply kind of across the board or to multiple chapters. So I've addressed them up front. The first one is a continuation, I guess, a short summary of what's addressed in the paper in more detail about how part 2 is given effect to. The RPS, as notified, took an approach where if there is a conflict that the decision makers had to prioritise the natural environment. And there was also, it tended to take an approach where the provisions were drafted to protect, essentially institute minimum standards for the natural resources, and then whatever people wanted to use them for once those standards are met was the RPS was not tended to be on the quieter side. There were a lot of submissions on that approach, and so in response, staff did agree that providing for the use and development resources is a part of sustainable management, and so amendments were recommended throughout the RPS by staff and council to better reflect that use aspect. Ultimately, where ORC's council landed was that the implications of the Port Otago decision meant that that kind of prioritisation, it was an approach to resolving conflicts, and then the Supreme Court came out and said, here is the way that it should be done. And so council recommended adopting the same tests or the same process that the Supreme Court used in Port Otago to reconciling conflicts, which means that in some cases, depending on the wording of the policies in question, it might be that an enabling provision for development or use overrides a protectionist one. So the panel disagreed with the argument put forward originally about the prioritising the natural environment, but ultimately where they landed was that they agreed with the amendments that council put forward in response to the Supreme Court decision. So there's a lot of commentary in the report, which is I personally find very interesting as a planner. But I guess it's an interesting one where ultimately where the provisions landed was that the panel agreed with the recommendations. They just kind of came through down different pathways to get there. The panel did clarify that in the case of the NPS FM, there is a hierarchy that must be implemented. And that's, the panel found that that was acceptable because of the level of degradation of water bodies across New Zealand. And so it qualified as a particular type of situation where you could prioritise protection, and acknowledged that that was lawful. And so agreed with staff that the hierarchy of obligations in Te Mana o Te Wai should remain. Because most of the provisions in the Land and Water Plan are under the NPSFM hierarchy of obligations, rather than the the more general decision making that we were talking about under the Part 2 discussion in the RPS, there hasn't been a significant change in the Land and Water Plan because it was designed to give effect to the NPS.
Ron?
Cool. So we previously had a debate about the implications of the RPS on our land and water plan. And it's interesting just looking at your table that the only significant implication is wetlands and the others are either none, limited or moderate. And maybe to get a question over that statement, what is the difference between moderate and limited?
Yeah, that's a fair question. I would say limited is tweaks, whereas moderate is actually we need to think about the way that we have provided for or not provided for this activity, and we need to more carefully look at the way that the RPS has addressed that particular issue. So it might be, for example, something like a change in activity status for a particular rule, or it might be changing and, it might be putting some qualifiers on some of the direction.
So it's a minor change.
It's relatively minor, yeah.
Cool.
That's fine with that, Andrew and Kate.
Felicity, with regards to the hierarchy with Te Mana o Te Wai and thinking about the principles as well, does the hierarchy influence the principles, or the principles influence the hierarchy?
That's a very good question. Technically, Te Mana o Te Wai is the hierarchy and the principles. And so I think the way that I tend to think about it is that the hierarchy is how you do it, and the principles are what you consider when you're doing it. So you have to have regard to those principles.
So the hierarchy is sort of like the rules.
Yeah.
Okay. And the other question I had was with reference to the hierarchy, and if you're in a decision-making scenario, would you be required, based on the hierarchy, to return the water quality to pristine state before you could give effect to 2 and 3 of the hierarchy?
No, that certainly wasn't the argument made by any of the submitters or by ORC. The way you apply the hierarchy is that you have to design and undertake your activity in a way that protects the health of the water bodies. It doesn't mean that you are responsible for restoring that water body to its previous, some natural state. It just means that you have to be doing things in a way that means that you're not, that you are implementing that priority at the same time as then, before you move into providing for human health needs and then the third priority. Yeah, I certainly wouldn't read it as it's a weighting prioritization exercise rather than a structured analysis rather than a specific gateway where you hit a limit.
Thank you.
Thanks, Kate, and then Karen.
I'm asking this question really in light of Brian's questions. It's the journey that this plan has gone through for those sitting outside and not being part of it, and those sitting in the hearings and going through it. And what is the impacts? So for those of us who didn't get involved in the hearing, and we saw the RPS as a document, and 2 years later, or 1.5 years later, or how many years later, we see it coming out, and it seems to have changed quite a lot. What I think this expresses is that because you've been sitting in the room and hearing those iterative changes and addressing them, you have been changing the land and water plan as you go through, possibly unbeknownst to us, or without that same clarity, so that it isn't a major change when the decisions come out. Is it? That's how I've read this paper, as being minor and major. Yes.
And yeah.
Yes. So I think it's really important that when we talk to people in Otago that haven't been part of this process, that limited, moderate, minor, none is your response to your journey, potentially, rather than what it might look like to them outside who haven't done all those steps. And I keep on getting this wee image of it's quite big jumps for some people to see those changes, but because you've been living it, you've been doing those jumps on the way.
You're absolutely right. The difference between the notified RPS and the decisions version, there are some very significant changes. The way that I think about it in terms of the land and water plan is that some of those changes were suggested by staff back in 2022. And so those changes have been, we've been aware of those, what we've been recommending in the context of the land and water plan and trying to align as best we can to reduce the amount of change.
Okay, and I just want to express it, not because Brian asked the question, but I think there has been again debate around this table and people aren't on the same page because we haven't taken people on that journey with us. I have constantly argued that I think this is a significant change in terms of the Peter Skelton report. I can understand now, only today, once I read this report, why you weren't of the same mind. But that doesn't necessarily work for people who haven't been involved in the process. Yeah, and it just clarifies why. I think we're been hitting ourselves over our heads at each other, which hasn't been helpful.
Thank you, Kate, for the points. Karen?
Hi, Morena Tata. I might be hitting myself over the head. Just wanted to follow up on Andrew. I'm still trying to understand what ultimately staff are recommending, because you said about remediation of the health of the water. And can you repeat again what you said about what's the state we're trying to measure to it back to?
The state that you're trying to achieve is the state that your target attribute states and your environmental outcomes set out in the land and water plan.
Yeah. See, I always like to go back to measurement, because I can't understand in those measurements how we're actually looking at the state of the water as Māori might measure it. And you know that what we do is go back to what we are told of pre our time and to mahi kakai relationships or other relationships. So it seems to me that the measurement we're getting is, it's okay because it's just getting there. It's not necessarily a measurement that takes into account cumulative impact that has occurred in that environment. And if we keep ignoring cumulative impact, whether it be in this instance or any other part of the ecosystem, we're inevitably going to be, in my view, working towards a gradual degradation of the ecosystems, because we haven't taken them back to their best operative state. So I'm just wondering how that level of definition of the goal we look for is measured. And again, that then of course takes me back to what the case law talked about. What is the purpose and intent here? So my personal view would be the intent is to have the ecosystem can function most pristinely as intended without interference. And then, as Whakapapa dictates, we learn to be part of it, not to gradually, cumulatively impact on it. So I'm just trying to get an idea of where we are at in our goals on this, please.
So the NPS states that where the health of water is degraded, it must be improved. The level of improvement is a question for communities. At minimum, improvement has to achieve the national bottom lines where there are some, but communities can choose to go further than that. So that's, I guess, in terms of quality, that would be, or in quantity, that would be the standard approach. For water bodies that are not degraded, their health has to be maintained. And again, that is in reference to, are they achieving the outcomes that the community wants for them? There's a range of views on where the outcomes should be set. And certainly we appreciate that Kaitahu would like to see a higher level probably than what we've put in the plan. However, there are costs associated with those levels of improvement. The one thing I would say is that we have worked closely with Kaitahu about the outcomes that mana whenua seek from water bodies in Otago. And there is an appendix in the land and water plan setting out what mana whenua aspirations are for water, which are more ambitious, I suppose, than some of the target attribute states in the plan, but the measurements, the numerics. Those are incorporated, and as a way of allowing decision makers to understand what mana whenua aspirations are and to assess the extent to which a proposal is consistent with those or not. It doesn't put a right of veto to mana whenua, but it's a way to clearly have in the plan what those aspirations are so that everyone is aware of them and it can be considered in a consent situation, rather than having to rely on mana whenua submitting every time and turning up every time to articulate those aspirations.
Yeah, that is helpful, but as somebody who's on DCMs, it's not a particularly powerful tool. At the difference between aspiration and expectation is, and also what you're talking about is cost. Well, my costs are that future generations will not have access to resource. It's a much bigger cost than a fiscal cost right now. So again, I'm sorry, I don't want to go on because I know that's not really what we're here for, but there is a concern to me about how we try to align those things, and appreciate that, okaha are an input, but that's one input. It's not necessarily this table's debate being strengthened enough, in my view. That's my view, whānau, is that actually the debate of the measurement of all of this is really key to how well this plan lands. Kia ora.
It's the hand up, Lloyd.
Thank you, Karen.
The hand up. Well, she's taking it down.
Oh, okay.
Alexa, was it?
Do we have any, thank you, Karen. Do we have any,
I was just supporting that comment, people. It's what my hands were doing there, and I've got so much light on me at the moment, you can't see me, so I won't put my camera off, but there we go.
thank you, Alexa, please just step into the light.
Moving on to the second row, which is about rural land. There were submissions from a number of parties stating that the RPS should contain a chapter on rural land. The RPS was prepared to implement the National Planning Standards, which doesn't contain a rural chapter as a mandatory chapter, and so there wasn't one. Ultimately, there was discussions between some of the chapter authors, and I guess what I would say is the Land and Freshwater chapter had provisions about soil quality, erosion, effects of land use on water. Whereas in the urban form and development chapter, there were a whole bunch of provisions about managing rural environments, and particularly managing the encroachment of urban development and expansion in those areas. And we did agree with submitters that it wasn't helpful to have those two quite key parts of managing rural environments sitting separately. Ultimately, we recommended combining them both into the land and soils section, which seemed like the most sensible place for them. And the panel agreed with that approach. The panel looked in detail at whether the planning standards allowed for a rural chapter to be developed, and I think shared some of the staff confusion about what it is that the planning standards do allow and don't allow. And ultimately, I think where they landed was that it doesn't look like, if you've got provisions that are dealt with in a chapter, then you can't create another chapter. But the panel ultimately did agree with the staff recommendations about moving provisions so that they were all housed together. A lot of the urban form and development type, or the provisions managing the use of rural land for non-rural activities, are really a district council function, and so they don't have a lot of impact on the land and water plan. and the highly productive land stuff falls into that category as well. But the Land and Water Plan has always contained policies on soil conservation and effects of soil erosion and land use activities on freshwater. So although there were some tweaks to provisions to just make sure that the language between the RPS and the Land and Water Plan is consistent, there wasn't a significant change in approach.
Thanks, Leslie. Do you have any questions around that approach of the putting the land stuff into one? If not, we'll carry on. Thanks.
Sure. The next big topic, I guess, was loading. In a number of the land and freshwater and coastal environment provisions, there were references in the RPS as notified to restoring or protecting loading. In response to submissions by Kaitahu, some staff recommended additional references to Māori in certain provisions. A number of submitters had concerns that Māori incorporates a spiritual element. It can be called the life force, and so the cultural evidence from Kaitahu and Ngāi Tahuki Mirihuku really talked about how there is for mana whenua there is a spiritual element of determining whether whether Māori is being protected or not. Submitters' concerns were that would inappropriately curtail decision making to mana whenua if they are the only ones who can make the spiritual assessment of Māori, then it would. The submitters just didn't think that was appropriate. The panel did agree with submitters that there are practical difficulties with the way that Māori had been used in some of the provisions, particularly where it was an absolute outcome. So the outcome was to, might have been to protect or restore Māori, and the panel had shared the submitters' concerns that only Kaitahu would be in a position to do that. Interestingly, though, the panel didn't remove references to Māori completely. There were some cases where they did remove reference to Māori from provisions because they didn't think that the context was appropriate. But there were other places, particularly in relation to freshwater, where the panel pointed to the way that Māori is described in the NPS for freshwater management, which is an outcome of applying to Mana Otawai. And in that context, the panel thought that it was inappropriate, that you could change the language slightly to clarify in those provisions that the Māori is protected or restored by applying to Mana Otawai. It's not just an absolute thing that requires some type of external assessment. So that was a reasonable change, and there were a number of references to Māori throughout the draft Land and Water Plan. All of those references have been reviewed, and individually there have been some changes to ensure that the way that they've been used is consistent with what the panel's recommendations were and the way that the wording is now in the RPS.
Thank you. Karen?
So, I understand what's being said, of course. However, it worries me that the panel wasn't taking on board that there are ways to deal with Māori, and of course it increases partnership of mana whenua in support of mana whenua. So my question is do we have to agree with everything the panel's recommended in this instance?
The time for either accepting or rejecting the panel's recommendations was when the council made its decision in March, I think.
Okay.
So,
Okay, so the council has already determined that. Okay. All right.
I would say there is a live High Court appeal on the key objective in the Land and Freshwater chapter that addresses loading, but from memory, I don't think it is. I don't think the subject of the appeal is how Māori is referred to. I think it's something else.
It's just that we've now moved on, of course, to the Māori of the whenua. And I think that, so of course, council's in charge, accept that completely, but I think this should be noted for, if it's possible, this is a live issue because it's about strengthening capability of everyone to have more tools in the kite. And I understand people are concerned about bringing in a new knowledge base, but actually the new knowledge base will give extra tools for the end goal. So appreciate that, just like that noted really. Yeah, I do.
Thank you, Karen. We'll certainly take note of that.
Rows 4 and 5, I'm not proposing to, oh, sorry,
Yeah, 4, mine's about 4.
okay.
Yeah, so I do want to talk about.
Okay.
And I didn't want to pick you up on rural. I think I took a relatively different approach about the rural chapter, being that they couldn't put one in at that late stage because there wasn't one that had been prepared
Yeah.
and proposed, and therefore it couldn't go in. The question I asked last week, if anyone can remember, on the vegetable letter to the minister, does relate to this. Food and fibre, we produce it on the farms and then it has to be processed. And there's actually, if it's been, and there's a big gap between that and what we provide for. And again, because we've got an objective only in Dunedin and the coast, which provides for industry and commerce, but doesn't in any other FMU, I'm really concerned that we're not providing for food and fibre production to be processed locally, and how we're going to fix that. So having read the decision, having read the draft plan, I am concerned that we're going to be requiring everything potentially to go to Dunedin, because that's the only place we're enabling it in what I've seen. And that's just done in this current world with climate change and carbon footprints, which we should be minimising. So I'm just joining all of those dots together and saying that I'm really concerned about this response.
You're correct that that environmental outcome for industrial and commercial uses does only apply in that FMU. Tom and I were discussing the environmental outcomes yesterday, and they are on the list for discussion with councillors on the 28th of May. And I think where some of those environmental outcomes that were only identified for specific FMUs, whether they should apply to more FMUs, I think is part of that discussion. Certainly it was in the clause 3 feedback, there were parties seeking that environmental outcome be included everywhere. So that will come back to you on the 28th workshop.
And therefore that response may change.
Yes. Well, this is really just about the definition of the term, and the food and fibre production definition that the panel included in the RPS includes both the activities happening on the land and the processing.
Yeah.
Which is fine, but in the land and water plan, they tend to be, those two parts of the activities are often dealt with separately because they involve different activities. And you would want to be more stringent on some of the discharges from the processing plants than you would on the land use happening in the first place. So there is it's not an especially helpful definition in the land and water plan context because it covers so much ground.
Yeah. That's fine, as long as we're going to have that as live debate somewhere. I didn't want to miss it today because I think there are some things, unintended consequences from it.
Yep. Regionally significant infrastructure is a definition that attracted a lot of attention throughout the RPS hearing, and of course it did in the previous RPS as well. Staff recommended in response to submissions adding in a number of additional activities, electricity distribution infrastructure, certain other airports, community scale irrigation and stockwater infrastructure, oil terminals, landfills and ski area infrastructure. Generally the panel accepted those recommendations other than the airport's additions, and they included some additional roads which provide a lifeline connection for a community, but might not be, there's a roading hierarchy, and it might not be in the top few tiers that were covered by the definition originally. The recommendations on the definition of regionally significant infrastructure were made back in 2022, and so staff working on the land and water plan have been aware of those. There have been some changes, particularly around the infrastructure for irrigation schemes and stock water infrastructure, just to clarify in the draft land and water plan how those particular types of infrastructure are recognised in the provisions. Otherwise, generally the references have been to where there's policy direction, it tends to be about regionally significant infrastructure, and the definition will just be the same as what's in the RPS.
Thanks, Mr. Kevin.
Yeah, I'm just wondering your metric around, and if you're not going to include it, I wonder why you don't, because I'm probably disagreeing with the panel of airports servicing planes capable of carrying 30 passengers plus, or 30 plus passengers. And I particularly refer to Oamaru Airport that has to stay open as a safety valve if your plane doesn't quite get from Christchurch to Dunedin, and it has a hiccup, and also as a regionally significant, now it's a major training base for hundreds of pilots every year. So to us, that is regionally significant.
Oh, yes, it may be. There are some airports that are named, which include,
right.
so it's Dunedin, Queenstown, Wanaka, Alexandra, Belclutha, Cromwell, Oamaru, and
Didn't know
Taieri.
that then.
So they are regionally significant. Yeah, it's just anything, any other airports
Yeah.
in addition.
Cool.
Yeah.
Cool.
Thanks, Kevin. Brian.
I was just a bit surprised that ski area infrastructure is regionally significant. I mean, I would have thought there was a good chance that in 50 years' time it won't even exist. But it's regionally significant. So can someone just talk me through that?
Yeah, I mean, certainly the ski companies made submissions and were successful, I suppose you could say. They do have a pathway. I think the main tenet, this was a chapter that wasn't mine, so I'm not completely over the detail, but my recollection is that they do have a consent pathway under the NES for freshwater for some of their activities in wetlands. And so alongside the likes of other regionally significant infrastructure projects and mining and quarrying and some landfills. And so I think they ran an argument that they get special recognition in some of the national direction documents, and therefore they should also in the RPS.
Well, I suspect my question is really, what is the implications of being defined as regionally significant? Do they get a lotto ticket every year or something?
I don't think they get a lotto ticket. They do get, in some instances, they get an easier consent pathway. That doesn't mean that they can override the direction in the higher order documents, so they still have to comply with the NPS and the NES in terms of the activities that they are undertaking that affect water bodies or wetlands. But I guess there is some recognition that regionally significant infrastructure can't always mitigate all of its impacts.
Cool, thank you very much.
Thank you, Gretchen.
I'm just checking in on how much time we've got to go through this table, but also what we're aiming to do here, because we could be looking at the regional policy statement and whether we liked or didn't the way we've got to, or we could be looking at implications for the land and water plan. And it's probably useful to understand where the RPS got to at this point, but we're trying to look at, I would think, we're going with the land and water plan, what the implications are, and just making sure we've got enough time.
Yeah, I wonder, I think that's a good point. I wonder if the most significant implications come from the land and freshwater chapter, so I wonder if we just skip ahead to that one. And then from there, things tend to go more towards district council functions. And so I think there's a lot of stuff in the later ends of the table that probably we don't need to labour.
Oh, sorry.
I'm just keen to make sure we don't miss any questions that there might be on that stuff beforehand. So maybe can we go, are there any questions on row 7, questions on row 8? And just move at that pace until we get to that stuff. I just don't want to take the opportunity away, that's all.
So, Kevin.
Yeah, look, I'm really comfortable with that approach, and that what your final part out the right-hand side tells me that you're rewriting bits and pieces or not rewriting bits and pieces. So I'm probably more interested in seeing what the rewrite looks like, to be fair. And not saying what you haven't done is good, but I'm just saying that that's probably the proof will be in the pudding, I suppose.
Yeah, thanks, Kevin. Right.
We kicked it off by discussing the fact that all the implications were either basically limited, moderate or none. Limited, moderate or none. The only significant one was wetlands, so I would ask that we speak about wetlands.
That's my section, yep.
Thank you.
We're gonna go to 8.
So can we just carry on through? So we got section, we got on the second page of the table, we got like 8 through to 13. Or we just go 8, then 9, 10. Does anybody have any questions? Because these are all low impact ones or no really issues. See, there's 4 of them there. 3 of them, sorry. So that's all good. So we can carry on. Integrated catchment management. And then you have your renewable energy ones. So
We'll talk about that.
talked about that earlier on. Just like over the page, we've got
Sorry, actually,
sorry, Gary.
just on the decision making one, I mean, that could be limited or it could be significant depending on the government's proposed changes. So it's just to highlight that while we're saying that the hierarchy sits under what we've currently proposed, it's signalled to change.
Yeah, that's correct.
And
We're
with
just
that-
dealing with the NPS as it stands at the moment.
and that will have a major impact. Okay, thank you.
You good there?
Yeah. So can I just go back to 11? Sorry, and that's the on clause 3 consultation. Probably one of my biggest pages of notes was on iwi's representation in chapter 3. So I'm just, and yet you say there's no issues. So have we come to the right spot with our partners?
The RPS has to include issues identified by Mana Whenua, and so that chapter was prepared in the RPS by Mana Whenua, and they were largely the only submitter on them. So there weren't significant changes in terms of the actual issue statements themselves.
Yep.
They are large issues though.
Right. So, yeah, but what I'm saying, that's on the RPS, but have we reflected the clause 3 through into the land and water plan?
Oh, yes.
Sorry.
Yes, yeah, yes, we've received clause 3 feedback from Kaitahu, and particularly in relation to how these issues have been addressed in the land and water plan. And in a number of cases, we've gone back to Kaitahu and worked with them to refine some of the provisions.
Yep.
Including in particular, one of their main comments was that the strategic direction was a bit spread out over 3 chapters.
Right.
And so I've worked with them to put it together into one.
Yeah. So Chair, just to follow up on that, so when we get this first look of the good work you're going to do, will you give it to us as a tracked version, so we can understand where you've reflected either RPS movements or clause 3s or just changes of thoughts?
Oh, as someone making these changes, we are doing it in track changes
Yep.
for that purpose, so that it's clear what the changes have been since the clause 3 version that went out to parties.
Yep.
So
Yeah, I think in general the answer will be yes, but there might be some cases where that gets really messy, in which case we'll.
I appreciate that. If
Yeah,
you give us
we'll- So yes,
Asterisk.
with an asterisk,
Yeah,
exactly.
cool. Yeah.
Yeah.
Thank you.
And so the intent is to cover that, that briefing in early to mid-July.
Yep.
So, yeah, we haven't got a date though. Yeah.
Thank you.
Thank you. So we're on to renewable electricity. The last one, number 13. And we covered that probably in the preliminary, talking. Over the page 14, contravening limits. It's, nothing there, here. 15 here. Everyone's happy enough. Coastal environment. Everybody seems pretty happy there.
Sorry, Lloyd,
Good. Oh, sorry, Andrew.
just jumping back to here and the conversation we had about section 70 and 107. Would potentially the same thing apply if you had air quality below the national recommended standards, attributes? Would potentially an outcome like the High Court decision in Southland could apply with a situation with poor air quality?
No, section 70 only applies to discharges to water or to land.
But just in that respect, the NS air quality order restricts your ability to issue a discharge consent for industrial activity in an issue that doesn't meet the quality standards. So it's kind of already there.
Same sort of.
Sorry, yes, we have Michael on screen.
Sorry, just to let you know that I will never vote for 18 Te Mana o Te Wai and retaining the hierarchy of obligations when particularly they are to be got rid of by the government. So I can't support that.
Thank you, Michael. I think we're moving along. Coastal now on to any other questions around the Te Mana o Te Wai area? We had quite a discussion about that earlier on. Integrated catchment management. Everyone's happy enough. Freshwater. Does talk around the bound.
Long-term visions.
Overrated.
I want long-term, number 21.
Number 21, yeah. So the number 20 was around the boundary changes, I think. So that's all pretty much understood. Long-term visions, and Kate has a question on long-term vision.
Mine's, I think, a process question. There isn't much in the FMUs that distinguish each, and I think it's the weakness of the land and water plan because we have, as I think the RPS decision and many other bits that we write about have one of them, if not the most divergent in regions in New Zealand, and yet they're all look very similar when it comes to both the visions and the policies under each FMU. The timeframes have been extended here. When and we've talked about updates to the land and water plan, and where do I go to find what the proposed work program would be on those to get the timeframes? Because I don't know that they were in the previous timeframe that we had. Going out for, I heard the other day, for another 5 years, for example, for the FMU for the Taiawe, which was longer than I had anticipated, especially given what we were told in Plan Change 7. And so I'm just trying to get my head around all of this and how we distinguish the FMUs, because it's a real fraught. It could be where the most stuff happens, but it could be a real it's hard to articulate the question because it's the Achilles of the plan is that we haven't really used the FMUs a lot to drive what that vision for each and to show how different they are. So we haven't got rules that distinguish a dry catchment to a wet catchment when it comes to cultivation, or the same rules apply for deering as in the Tari as in the Pomahaka and those sort of things, which just don't look intuitive.
And your question's hard to articulate and the answer's hard to articulate too, because it's not.
You do understand where I'm going with.
Yeah, I do. And I was reflecting actually on the Taiari the other day, and part of the reason we haven't pushed changing the flows is because the consents don't expire for another 20 years. And there was or most of them, there's
You
a.
tell that to someone affected by Plan Change 7,
Yeah.
and it will be doing it twice in that time with Green.
Yeah, so but there was, some other challenges, but in terms of work programs, they're not gonna sit in the plan. It's gonna be a matter of, well, one of it's gonna be around plan implementation and the non-regulatory stuff, and depending what's in the LTP. There's a whole lot of pieces of the puzzle we've got to pull together in terms of how we make sure we get where the visions are going.
And that's fine, but this will be a litigious process unless we have a really clear alternative pathway or ICM program or understanding what could be in CAPS.
Yeah.
The other CAPS, we need to get new names for these things. Sorry, CAP and action plans. We've got them in the regulatory and in the non-regulatory space, and it doesn't make sense to me. But that is really important if we want to stop this being fought. And we're not articulating that well here to date, and that's it could be a really good process, but it just doesn't seem to be connecting up. And I'm just even articulating this here doesn't do it for me.
Yeah, and the challenge is the plan will only ever deal with the regulatory stuff, and the whole picture as ORC is the non-regulatory together. So some of the section 32 will talk about some of the non-regulatory stuff that will pick up the action or do some of the work that either supports or complements what's in the regulation. You're never going to see the whole picture in this part here because it's the regulatory part, and that's the problem. But yeah, we'll have a think about if there's a way to pull it together and show you what's happening.
It is still going to be, sorry, I think the weakness is that we do not show well enough in the visions and in the chapters the distinguishing parts of those, whether it be climate or whether it be soil types or whether it be existing vegetation and biodiversity values, that you don't then see something driving the rules. And I think we could be. I think we know our environment so well, and we should do. It's an absolutely brilliant place. Love Otago. But if we can't articulate that into those chapters and give that picture, then I think we really leave rules that give the same the same answer in each FMU. That just doesn't look plausible. And yeah.
It's okay, I think it's really quantifying and working the differences between each area. So it's actually they have their own special circumstance.
Yeah, absolutely. I mean, where you've got a puggy ground, then you shouldn't allow as many dairy cows as you do in a dry area. We all know that.
So so I think we'll take that on board and have a bit of a think about that, how
We have
progress that.
we have tried, and it didn't land particularly well around the table, so then we removed some of it, and certainly the conversation that I've had with Dairy NZ around intensive winter grazing was for them to come to us with rules that actually reflect the differences of the FMUs, and so that's the meeting that Fleur referred to earlier. And some of that refinement we talked about quite early on in terms of the science spaces, we didn't necessarily have enough to build that differentiation in yet, but it would come in time. But if you can see opportunities where you think we can differentiate, we'd really like to try to.
It's that time. How long will it take in showing us that time? So you give that certainty. That's what I don't see.
No, and you won't see it in here, but that is part of things like the science. Tom's not looking at me, but it's part of things like the science work program, and I'm deliberately avoiding eye contact. That's what that sort of stuff does, and enables us to start to gather the data, because we've never collected this data before. That's one of the challenges we have, is this plan is the foundation to enable us to bring some of that information and that we haven't collected in the past, to enable us to make those decisions and provide that direction, and that's what it will do. And 5 years, I would imagine, of data the team would like to have before they make recommendations.
Yes, I think with particular reference to the tidy,
Microphone.
With particular reference to the tidy, we were looking at 5 to 10 years down to be able to get from where we are today to a place where we can confidently recommend significant flow regime standards, settings, and changes if required. But that will all come out in a broader program of work. So we've already started with net studies and other pieces that support that. groundwater studies to support that. Those are long lead time studies, but there's also hydrological studies that need to occur as well.
Yeah.
I think we gotta be really careful we don't get bogged down on this one, but I think we've got the points being noted. And I've got Kevin's got a question as well. I assume it's around this, Kevin.
Yeah, that's look, it's probably just more a comment really, Chair, is that the key to this plan and the next part of the plan where we have got this, those descriptors probably not as good as they're not as good as we want them. And I don't know when they will be, but it's showing where we're going to plug those gaps. So, and that's around making it very clear to the people in each area where our non-regulatory tools are going to come into play, and also what our programs are going to be. So on the TIRE, we've got some consents coming up. We're going to have to do some work with them to keep them going until we get to our final position, which could be 5 or 10 years away. So that's the key stuff to me, that when we notify that we're going to have those sorts of things in place to really bring the public, our people with us. Yeah.
Yeah, look, I don't want, look, it is really important to me, and I don't want to use Tyre as an example. I'm going to use Catlins, and I've asked questions of the Taha Kopa. You know, where you've got a really difficult environment to farm, if you're not putting that in there, because the paddocks are relatively small and there are so many creeks, if you don't see that or that isn't written in, and you get rules that say 20-metre setbacks, you need to know that stuff in order to be informing the rules. And the rules might look fine in Lower Clutha, but they may look really, really in the Section 33 report. And if we're not putting those things up there and understanding that, then that's where I get really angsty, that we're not turning our mind to actually having a research, just perpetuate a real litigious problem to be fixed.
Thanks. Thanks, Kate. I think we'll carry on again. So we'll carry on. We've got transitions over time, water allocation.
You're dealing with it later.
And I think the wetlands are going to leave. Are we doing wetlands now?
Yes, I'm happy to give an overview of the wetlands issue,
Yeah,
noting that
yeah.
probably it's best to leave your questions for the workshop. This one was especially difficult because of the number of changes to national direction that happened in the management of wetlands over the course of the RPS. The NPS changed twice, and so did the NES between notification and the end of the hearing, which meant that there were, it was an ongoing issue throughout the hearing. And you'll be familiar with the issue of natural inland, the definition of natural inland wetland, not always capturing some wetlands of value. So what was proposed by staff was the same approach that was proposed to be taken in the land and water plan, where you apply the NPS for natural inland wetlands, and then you have a category of natural wetlands that wouldn't fall into the natural inland wetland category, and you protect them from the most destructive types of activities, a limited range of activities. The panel, and I have to admit, I found this part of the report a little bit hard to follow. The panel disagreed with what the staff advice, and considered that it was too stringent, and that what was being proposed for those natural wetlands was too onerous. But the amendments that they have recommended are considerably more stringent than what staff were proposing, because they now apply the NPS framework to all wetlands, not just natural wetlands and not just natural inland wetlands, but any wet area. And so there are significant implications for the land and water plan provisions, which were predicated on differentiating between these types of wetlands. And there are going to be some options for you to consider at the next workshop. But I guess worth noting that there have been appeals to the High Court on the key wetlands provisions in the RPS, and like they did in the hearing, they canvass a spectrum of appellants seeking stringency and I guess from one end just implementing the NPS as it says and doing nothing at all extra, through to some appellants who are seeking to retain quite a lot of the additional stringency that the panel has recommended. So that one will be difficult.
So basically what we've got here is actually the findings of the RPS panel. And we'll be talking about the applications for land and water plan at our next rodeo on the 28th.
And I suppose it's worth noting there that the way the High Court works is that they often don't make decisions on what the provisions should look like. They make a decision on whether there's been an error of law, and if there has been an error of law, then they may well send these provisions back to the panel to reconsider.
Thank you. Carry on. Next page. So the next page we have 24. Kate, you've got
25.
25, stormwater.
So I understand the issue here, and the only thing I've got written down is timeframes, because it wasn't clear to me the timeframes for the stormwater, and it probably relates to the next one as well. Because we've got some of these that we're doing by consents now, and some will be outside the timeframes, I think, for the vision, the timeframes for the improvement.
Yes, so in terms of stormwater, most stormwater discharges, well, all stormwater discharges, unless they contain sewage, are currently permitted. So councils don't have consents for those discharges, and they will need consent for those discharges under the Land and Water Plan. That requirement will come into effect 6 months after the plan becomes operative, so it's still some years away at the moment. That will be quite a considerable shift for stormwater discharges.
Although that they haven't been appealed.
No, that policy hasn't been appealed, no, so it's just in place now.
So the 6 months happens when the whole plan?
From when the Land and Water Plan becomes operative.
Sorry.
Yeah.
Okay.
In terms of the wastewater, which is row 26, you're right, those discharges do have consents, and some of them have quite long expiry dates out into the 2040s, late 2030s. That policy will be implemented when those consents come up for renewal, or earlier, from 6 months after the Land and Water Plan becoming operative, if it's a new discharge that doesn't have a consent at the moment. And I guess harking back to Philip's summary of the case law at the moment, that those decisions on section 107 are going to be really problematic for some of those discharges.
That's okay. That's great. Thank you. That's murky place.
Thanks, Maggie. So we can carry on moving along on that pace. Andrew, you got a question?
Just a quick one. It's probably for Anita, and I remember asking the question before, I don't know, months ago, about any, and this is to do with wastewater discharge, just in general. And is there going to be any reference in the section 32 about the costs and benefits associated with this type of policy going forward? And why I asked the question, it's probably more relates to social wellbeing aspect, the impact potentially of rate increases over a period of time. So that's why I'm asking the question.
So every objective is assessed under section 32, and then the assessment is whether the policies and rules are the most efficient and effective way to achieve the objectives that section 32 does. So it will be considered.
Thank you.
Yes, and I'm aware that the author of that section has been going through the TA long-term plans to find information about the costs that they've been budgeting for upgrades to their systems.
Thank you.
First, he gives a wee bit of rundown on your outstanding water bodies.
Yes. So there were some recommendations to narrow the criteria for identifying outstanding water bodies through the RPS, and that was the staff recommended version that was used in the identification of outstanding water bodies that's been used in the Land and Water Plan. The panel made a couple of other minor amendments to a couple of the criteria for natural character and for landscapes. So we have sought advice from the consultant who did the identification exercise to check whether the amendments from the panel are likely to change their assessment. they are preparing a memo, written advice on that. But I think the takeaway would be that they don't think the changes to the landscape criteria will have any impact on the assessments that they undertook. But the natural character one, possibly there will be some change. At the moment, there are a large number of water bodies identified under that criteria. And I think the panel's amendments have pushed the consultants to relook at the way that they did that assessment and whether there are ways to, whether the panel's recommendation now means they need to take another look.
Just was figuring that's what the last bit says. Okay.
Two comments or discussion with. One is, I think the decision report gave some really clear direction. I would be surprised if it doesn't change the number and quantity, especially given the comments on naturalness. And I think it was quite directive. I'd be surprised. But one of the things that really concerned me is the ability to know what is an outstanding water body, because none of them are named, or very few of them are named. And that just a carte blanche everything over every range. As sympathetic as I am to that, but the effects being quite problematic. There are so many ones that could have been given a name or are named and weren't named in the document. Are you addressing that as well?
In terms of the natural character water bodies, there are a lot, and that is the focus of the work that we're doing at the moment, is to see whether they can be narrowed down more from. It's the advice that we're getting is that natural character is really a degree of modification, and if there's been no modification to these water bodies ever, then their natural character is as it was pre-human times, and therefore they're outstanding for that reason. But it means that because of how many mountain ranges there are in Otago, that there are a lot of water bodies that haven't been modified, and so it's resulted in these high numbers of outstanding water bodies. I don't know what the outcome of that is going to be, other than that we are certainly looking at ways to get the assessment to more clearly outline which ones are outstanding.
And the only other one is that I know that there was an example on the Rocky Pillars of one that already had a take on it, and it would have been gazumped.
And there have been refinements in response to clause 3 feedback and the consultation that happened with the public last year about to remove parts of rivers where there is a take. So all of the take points have been relooked at, and any that are on a water body that was considered outstanding for natural character, they've been removed if there's a take point on them.
And I think Councillor Wilson, you sent two specific, I sent two from you through that one and one about the Blue Lake, maybe.
Yeah, I think another one. The question is whether they're active takes or whether they're takes that have been sitting there waiting to be activated as well. And I don't know if those have been addressed, but that's a different matter.
The other feedback we did receive was around the mapping and how it was problematic, and we're definitely trying to fix that and make sure that it's a lot better.
It's awesome. So it says we do work in progress there. Good, yeah. Carry on. I think what we'll do is just carry on, and if people have got questions, we're sort of in the scheme now. So you got where you next one? Oh, just around 32 significant natural areas. I was just wondering how that fits into our plan, because we don't really deal with.
Yes, and I think that it has come to light in doing this exercise. It's not clear whether the panel specifically considered that the biodiversity provisions should apply to freshwater environments or not. Some of the provisions are clearly have place obligations on ORC in relation to the areas that it's responsible for, freshwater, coastal water. Other provisions seem to suggest that these only relate to district council functions or district plans. There have been a lot of appeals on this chapter from a lot of different parties, although not as many as I expected to be
Yeah.
Yes, yeah. And I suppose one of the questions is whether it requires ORC to identify significant natural areas or whether that is, as it is in the NPSIP, limited to district council functions. And I suppose now there are live appeals on these provisions, which will, I'm sure, traverse that issue. But we've also got a signal from the government that there's going to be changes to the RMA, which will override what's in the RPS anyway. So I just don't know, I guess, at the moment, what the impact is. It will depend on whether the chapter applies to freshwater environments, but also if it does, what the implications of the government's changes are.
Thank you. So it's on hold, it sounds a little bit. So just moving through, Kate, you had a question for one?
Oh, just on 38 and reading it, and it's, I don't know whether getting to the engineering team on doing all of this work by the 30th of June, but it occurred to me that the monitoring equipment we have could actually be, is it provided for in areas of outstanding water bodies or natural landscapes? Because reading this is a whole lot of work yet done. We haven't done it particularly well, the natural hazard stuff right across the table. And they're not really a lifeline asset, but they are really important.
Are you referring to ORC's flood protection?
No, not flood protection. There's a whole lot of monitoring stuff we might be doing with.
Sorry.
Permitted activities.
Yeah, they're a permitted activity.
If it's monitoring.
Yeah.
Of any sort.
So the protection for those areas is from inappropriate use and development, and monitoring is generally inappropriate use.
It depends what monitoring's for though.
Well, yeah.
you asking gold mine. Thank you.
I got a wee bit confused around this one myself, to be honest. I've got it all highlighted here. So it's just around, because in your impacts on the water plan, sorry, the impacts on the water plans talks a wee bit about existing work programs. And so if those work programs are not completed within that time frame, they'll have to be noted or.
Yeah, so basically what the RPS requires is a map showing the significant risks of different types of natural hazards across Otago. And that is the work that's been, that's nearing completion by ORC at the moment. We drafted some of the plan rules so that a limited number of permitted activities couldn't happen in an area of significant natural hazard risk, whether it be from, often it's in relation to flooding. For example, not putting an effluent pond necessarily, or not putting an off-stream storage pond in an area of significant natural hazard risk. That has been done on the basis, those permitted activity conditions only work if there's an associated map sitting behind them, so people know whether they're in a risk area or not. So if the maps aren't ready by the time the plan is notified, we will have to revise the way that we've used those conditions.
Yeah, okay, so it's about the mapping of this significant natural hazards and whether the map's completed and is complete in time. That's good. There's only 3 or 4 left after that. Is there any other questions around the table? On screen? Anyone's got a hand up? Well, that's pretty excellent, really. Any other general questions around the RPS decision and how it may affect us? Thank you, please.
I think the timeframes for both the Catlins and what's one other that changed, and understanding how that changes, I think, I don't know that there was one in there, but we had iterative steps on some of them and whether that changes, because I didn't see that clarity. It'd be good to know, but that's something that's in the pediatric Zoom.
So that's one of the topics we'll be talking about next week. Not next week, sorry, the 28th.
Yeah, no, that's good.
Yeah.
Well, no, thank you very much. It was quite a very good session. It's quite technical, I guess, at the end of the day, but it's a good background that we all need as we, move, their minds change from the overarching document to the working document and the regional water plan. So, and even better, we've caught up quarter of an hour. So I don't want to let you get too much time for lunch. I think the next session, we've got Matthew McCarthy, he'll be on screen, he won't be wanting, he'll be organised for 1:15, so we'll break now until 1:15. And we'll start on the forestry provisions.
I'm gonna go and see a area before.
Go. We'll just recommence our workshop. So it's good to have a good break in the middle of a workshop for lunch, so it was quite good to have a leisurely lunch, so that was excellent, everybody. So next up, welcome to Matthew on screen, and we've basically got clause 3 feedback in the forestry division, so I'll just let Matthew take it away. Thank you. Well, Matthew, you take it away.
Thank you very much. Good afternoon. I have, or you should have item 5 on your agenda, which is the paper for this session.
You all have that, Matthew.
Thank you. If I just give you a quick run through the whole thing, and then we could move into questions, or would you like to go through it part by part?
I think the best if you give us an overview of the paper, and then we'll have questions at the end.
Very good.
Yeah.
If you turn to page 2, you'll see that there is a summary of the provisions that were consulted on, focusing on explaining what was in the clause 3 version in relation to both planting new forest and replanting harvested forest. There is also a section there explaining what is in the clause 3 version on harvesting and in relation to discharges. So as you'll recall, there is a permitted activity below 10 hectares in area, and a requirement for consent for replanting or new forest over that size. Over the page, there is an overview of the effects of forestry. And there is some information there on water yield, buffers, and sediment. We've also, in the intervening period since we talked to you last, obtained some updated technical information from the science and compliance teams, and I have summarised the 2 memoranda that we have received on the following pages. Those memoranda are attached in your agenda in full. On page 5, there is a summary of the clause 3 feedback. It's fair to say that there was both ends of the spectrum covered in terms of that feedback, but a majority of it is from the forestry sector, who are, if I had to summarise this very briefly, I would say that there is strong support for reliance on the National Environmental Standard for commercial forestry, and not having particular provisions in the plan. On to page 6, following that additional technical information and considering the clause 3 feedback, we are recommending some changes to the forestry provisions, separating new forest planting, which we would recommend still be subject to a consent requirement once it's over 10 hectares in area. The replanting of existing forest, we're now recommending that it rely on the National Environmental Standard. And for harvesting, we are continuing to recommend a low-level consent requirement to manage practices at harvest time. There is also a relatively minor issue in relation to bed disturbance in terms of carrying over the existing rule that protects beds of rivers from harvesting activities. As I say, attached to the paper are the two memoranda from the science team and compliance, and also at the very back there is a little bit more explanation of the feedback that was received, sort of a 2-page summary of it there. So happy to address any issue or answer any questions.
Thank you, Matthew. Brian, you go.
Cool. I think you're getting there. I think you're getting there. I've got 2 questions. I mean, the fact that with your replanting, the reliance on the NESCF, well, it seems to me addressed a lot of the forestry concerns. I'm not sure what the percentage of new forestry is. You've got no change and it's discretionary. Fundamentally, my first question, fundamentally, there was the distance, the setback distance. And I think initially you're looking at 50 meters, and that caused a lot of angst. If it's discretionary, where has staff settled in terms of that setback?
The version that went out for clause 3 consultation has a setback distance specified of 10 metres if that's predominantly Indigenous vegetation, and 20 metres if it's not Indigenous vegetation. And those are from a permanently flowing river or one that flows continuously for more than 3 months of the year. So it's not all water bodies, and it's not particularly on hill country. In my opinion, it won't apply to a great number of smaller water bodies on hill country. That applies to forests less than 10 hectares in area as a permitted activity. Once it goes beyond 10 hectares in area, which is in reality most of the genuine commercial forestry, then it goes into a restricted discretionary activity, and there is no specific guidance as to what those setbacks should be.
Yeah, that's fine. But so we've had all the thanks from the forestry sector saying, 50 metres is going to be no land to plant forestry. So I ask again, there mightn't be any guidance, but where have staff landed in terms of that setback, or are we kicking the can down the road, to see how it all transpires with your discretionary consent process? Is it going to be 20 metres above 10 hectares that's marched out? Is it going to be 30 metres?
The technical advice that we've got identifies that setbacks in many locations are having a single setback distance may not be the best way to go as a blanket rule, and that
I'm not talking about a blanket rule. I'm not talking about a blanket rule. I'm talking about where is staff thinking, because it's going to transpire at some point.
Depends on the conditions.
Yeah, I know, but
the reason for a discretionary activity is so that each application can be considered on its merits and enable that solution. And that was the feedback, is that the sector and council didn't want a one size fits all. So that would have potentially made it a restricted discretionary if you had one size, but that wasn't the way that the direction went. So we've gone with discretionary, which means that people can put their application together, suggesting the setbacks that are best for their set of circumstances, the mitigations that they want to put in place to ensure that sediment doesn't get to waterway, and then that can be considered case by case.
yeah, cool. Okay, so maybe some examples of some cases, because that doesn't actually satisfy me, because initially we went in and we said, this is our view, and there was angst. Now we're saying, oh no, it's just restricted to scribble, do it case by case. But where is it? So are you able to give me an example of some cases? Like, what really is that range? what is the maximum range that you could foresee in a non-Indigenous situation above 20 hectares with a certain gradient? You know, is it back to the 50 metres thinking? Or is, you know, and what's the range at the other end? Because that's all going to, because we're going to sign off this land and water plan, and it seems to me it's also understanding what's behind it.
Sorry, no, I was just gonna say, the point of it being discretionary is that we don't specify. And so that's the same as discretionary. There's a whole lot of activities that we have said as are discretionary.
Yeah, and so
and it will be up to an applicant to decide what they think is appropriate, and then for our consents team to assess whether or not they think it is.
yeah, so
So I can't give you a case because we don't have the rule yet. And I don't know what someone's gonna put forward.
I'm just not finding it very helpful because, you know, has staff, I'm trying to ascertain on the ground whether staff thinking has changed, you know, or whether in fact it hasn't changed, and that will transpire through the consenting process. That's what I'm trying to ascertain, you know, like.
I think Matthew's gonna.
Yeah, I was just going to say that I think staff's view has evolved, partly on the feedback we've had, but also in further looking at, often it's not just the size of that setback, it's often how you treat it, how it's managed, what kind of vegetation's in it, what other things might be being done to mitigate sediment risk. So it's often not just a simple size thing, and that's the whole point of a large forest that can be considered.
Yeah, but typically, what type of range would you expect? Like at the upper end, are we still looking 50 and the bottom end 10?
No.
Okay, so I managed to get that information. So what would be the top end range in a situation?
So the two different processes, and I understand your question, Brian. So the staff have had a change of direction based on the clause 3 feedback for how we manage it in the plan, and obviously you're seeing that in terms of the recommendations. So moving away from one size to discretionary, which allows the applicants to perform. We can't say, and we wouldn't say on public record at a workshop or a meeting what staff consider to be the top range until we saw an application come forward from a company looking for consent for this activity. It wouldn't be appropriate because we don't have any information in front of us to assess. What it enables is flexibility and case-by-case management, which is what we heard was far preferred to a blanket rule that set up a setback that everyone had to comply with. But we can't speak to what consent staff may consider because they wouldn't make that call until they have the information in front of them.
Thank you, Kate.
I've got a number, but I'll just start with 2, and let other people have a chance. Just taking on Karen's issue earlier about cumulative effects, and I think I know the answer to this, unfortunately. Can we give a land use consent just for one term, as in one cut, and then to be reconsidered? Or once they've got it, is it just inherently an existing use right? Because it's a land use consent.
For the regional council, consents are granted for a limited duration. So it wouldn't be a forever right.
So yes.
It can be, so you can, okay. Now, the next question relates, there's 2 bits that I drove down today from the wonderful Strathclyde and saw 2 things. One being the rocky hills around Sutton Stream, which have cliffs down to the Sutton. The horizontal setback there would be stupid because the hills would be north facing and have no chance of flowing into the Tidey because it's a cliff down into the Sutton Stream. And the question about setbacks that I posed earlier is about how that now works if there isn't a setback defined, and that if we're not going to use, we may not use definitions. At the moment, it's horizontal because you can have it 5 metres vertical or 10 metre vertical setback, or to the height. If your highest point is below, if your planting is below the highest point into that waterway, that's not a really good definition of setback.
Mhm.
And then I went past the Turquoia plantings where they've been avid tree planters and farmers for 3 generations now. And the question there is they do about 10 hectares a year and then they cut and they always have something cutting and something growing. Does 10 hectares 1 year beside 10 hectares from 5 years ago, beside 10 hectares from 20 years ago, is that 30 hectares of forest or is it 10 hectares of forest? Under or overs?
So I think, Karen, what your question is, if you have a 10 hectare permitted activity, can they be contiguous?
Indeed, and so this, I'm just testing the rules because we're looking at possibly the definitions changing because of other things changing, so we may have our own, and I'm just checking both those ones. Sorry, Matthew.
We've just
I
lost them.
was going to say that the rule that we have drafted has about 10 hectares of commercial forestry on a land holding. So
yeah.
it
Yeah.
wouldn't be a 10 hectares each year kind of thing, would not fit within the permitted activity.
And land holdings is a terrible definition because it's small sections or the whole land holdings. When it's actually, the risk is the size of the area harvested in any one time or planted in any one time. And I'm just trying to pull that out in my mind, what the risk is there. And yeah.
Okay, so we, you're happy there, Karen? End of the day, it's something we need to consider.
Yeah, I'm just
So that's
putting,
probably-
and the setback is the other one, is just understanding. I'm going to go back to these points in other areas, but understanding the definition of setback, if we're just going to take it as horizontal and not do the reference to the NPSFM or whatever it's in, because I can't keep up the number of regulations that we're referring to in there. But what should we be looking at something that's cleverer, that if it's a sloped situation in the gorge, that we don't worry about
Okay,
it.
So just on the setback thing, I know there are some parts of the plan where we have gone with a cleverer version of a setback, so we'll certainly look at it in all the areas that we have got it. In terms of the 10 hectare thing, that is about new planting of forest, so it won't apply to that situation you said before, that because the replanting is permitted.
Yeah, no, so the replantings, they actually do it in a really clever way and they turn things over and go into new land, but usually only about 10 hectare blocks, I think. You know, I don't mind purpose of judging land by view, but they're iteratively doing it, but they also convert some back to pasture. They literally work these things around, but it's only in about that size. And I'm just checking whether the land holding is the risk there or not. I mean, is that really the measure we should be looking at?
that's good, thanks.
We'll look at
Yeah, I think they might need a consent, just from the way that you're describing it, but they would be able to get a consent, sort of more of a global consent on that rolling basis. But that scenario, I think, would trigger at this point.
I hope it's quicker than our global consent, but that's another matter.
Thank you. We've got Alexa and then Kevin and then Gretchen.
Kia ora, thank you for this. Just wondering why under the key effects wilding pines aren't there and how they might be managed.
Because of pests earlier.
Just in pests, so we don't have it, they're not acknowledged as a key effect.
Wilding pines are managed under the NES for what's it called now, commercial forestry. Yeah, so I guess it's silent in the paper, but where those things are, we're relying on the NES.
Okay, thanks.
Thanks, Alexa. We've got Kevin.
Just the clarity from one of Kate's questions was, I'm not sure of the answer, if you could clarify it. So if I've got a block, a consented block, and I chop it down and go to replant in 25 years' time or 30 years' time, that won't need another consent, will it? Or are you saying that I do need another consent to replant?
The chop it down bit, as you put it, that would be harvesting, and that would require a controlled activity consent.
Yes, yep.
The the replanting of it would not require, under the recommendations that we are now making, it would not require consent to replant it.
Cool. So I'm not going to use my right to use that land for forestry, as it were.
Do you mean
Change
you
land
keep it
uses
down
and
for
things.
25 years before you replanted it?
No,
Right,
just in the,
yeah,
in the
no,
cycle.
yeah.
I do, I am slow, but I wouldn't be quite that slow.
No, it's me that's slow.
Yeah. So, just a question on the replanting, we've now gone back from, I think we initially had that we were gonna all replant and go into a greater setback rule, but now we've changed to run with the NESCF, which is quite hard to say, isn't it, really? So we're going to go with that recommendation, but what are we doing what are the rules around what actually happens in that, the non-plant, in the strip, and that, how's that managed and how are we going to monitor that?
The setback strip.
The setback strip, yeah.
That's what I'm referring to.
Matthew, are you there?
Sorry, can you repeat the question there?
All right, so I replant, and I can now replant to the new standards under the NESCF. So I replant, so my setback strip that I'm not replanting, who manages that? Because that seems to be the critical part where all the issues will come from if it's not done correctly. So how are we going
So the NESCF sets out some setbacks from wood bodies, and it would be up to the landowner to manage those setbacks.
I think Matthew, I think the question might be, just tell me if I'm wrong, Kevin, but if you have a new forest and you get it consented in the beginning, it grows, you chop it down, and then you're replanting again, to the setbacks, when you go to the
No, that's not the question at all. No, sorry, Lloyd.
That's my question then.
The absolute question is, at the moment, all our forestry issues are coming from existing forestry. So the newly planted ones actually haven't caused us an issue yet. So we're going with the scenario where the setback rule will be the national standard, and I've got no problem with that. But how do we monitor that setback is managed correctly?
So any rules contained in the NESCF are monitored by our compliance team. So there's a forestry program. So I don't know the rules, but you've got a report coming to regional leadership, which has a section on our forestry program. So you better ask those questions next week. But we do have staff who are regularly out assessing against that NES, and provided there are rules in there around the management of those setback strips, then they will ensure that they are meeting the requirements of the NES. I just don't know the details.
Perfect. Now that's what I want to hear. But I mean, I just need to know that, and I haven't read all the new forestry, commercial forestry, about how those should be, if they have got that managed. If they've got nothing in there to manage, perhaps we need something in our plan to ensure we are managing that strip.
Well, and it might be something outside the plan in terms of encouraging riparian planting or whatever in those new setback areas, freshwater farmland if they're on.
Yeah, but the intent of that, the intent of those setbacks are to manage the risk from forestry. So, look, I'm really happy with it, but I'm just saying we've either got to be monitoring it to a standard that's already set, or we've actually got to set a standard there that's workable.
So if you wanted more than
If I could clarify, the NESCF requires the submission of a planting plan with a whole bunch of information with it to be provided to council as part of its requirements when you do that replant. So it does provide a range of information that the compliance team will have when they're doing site visits and checking that that's being followed up.
But to rely on anything other than the NES, you'd need to go back to having a rule, and that was the direction that you said you weren't sure that you wanted. So we'd be going backwards to requiring a consent for existing forests to replant, and we've moved away from that based on the clause 3 feedback. So you need a rule framework. So the NES has got it. If it's not stringent enough, then you'd have to look at something else.
Yeah, well, I just, if you could direct us to a reading of that, what they think the setback should be doing. We know what we want them to do, so somewhere we have to have that articulated. And I'm sure they've got it, and that was the whole point of setbacks, but I can just point you some forests in the Kakanui Ranges where there's fires and all sorts have happened, and that's the reason why this policy has been rewritten, but the national statement anyway. No rush on that, but that's one
Yep.
view.
Noted, thank you.
Thank you. I've got,
Oh, sorry, and there's one more, sorry, on that, sorry, Lloyd. So why, if we go to horticulture and with freshwater farm plans and the like, it's 5 hectares, why is it settled on 10 hectares for forestry? And 5 hectares, if you know how big 5 hectares is quite a bit of lawn mowing each Saturday. Is there a particular reason?
I don't know the answer there, but that's the area.
I couldn't give you an answer on that in terms of a particular reason for the 10 hectares, other than that all the way through this, we've had that kind of threshold for smaller forests likely to be smaller areas on farm as farm forestry type development. That has been had a permitted activity around it from all the way through these processes with you, and I don't think that number's been re-looked at lately. So it's not in my mind as to its origins, I'm sorry.
That's cool.
Oh,
I'll bring some other stuff on it.
I think Tom Dwyer knows something there.
My understanding is that the 10 hectares is a nationally common threshold amongst other plants, was the reason for the landing where it's landed.
Thank you. Thank you. I've got.
Thanks, Lloyd.
Thanks, Kevin. I've got Gretchen, Gary. I'll go Andrew, then Kate.
It might be here, but the duration of the consent, whether that's specified for forestry, because cycles of replanting are important. But let's say we gave a 5-year consent, or a 10-year consent for the forestry to do whatever they want to do. And then they went to renew it, or they let it lapse, or there was a change in owners and wanted to do something slightly different, whatever. They wanted a different consent after 10 years. Would they be a new, could they be regarded as an existing at that point rather than a new and have different provisions? Or does the post-harvesting or whatever, but yeah, we just need to make sure that can't happen.
What can't happen? Sorry, I don't understand the question.
There's different provisions for new versus established use, but let's say they're a new forest, but they only get a 5-year consent.
Well, there'll be one cut.
And they let it lapse.
Yeah.
Would there then be an existing forest? Yeah.
Well, that was my question earlier.
Yeah. Oh, sorry.
Yeah, the
I might have
cumulative
missed
effects
that.
is whether,
Yeah. Sorry.
whether you can give a one cut life to.
Jonas, say that with you.
Yeah, so the way that the rule framework that we're recommending be set up is that you would get a consent to establish a forest, and that would include management of setbacks and size of setbacks and things like that. And then once you had that consent, you would establish the forest, and then the forest would have been legally established. Any additional planting obviously would require a consent, another consent, but that consent, in my view, could cover that forest establishment period, and that's the main period that there is a risk. While after the forest is established and it's growing, it's relatively static, and then you would require another consent when it comes to harvesting it. That consent would be a controlled activity consent for harvesting, and then the replanting of it, you would be under the NES framework.
Oh, that's what my question was earlier.
Yeah.
You said earlier that you could have a consent time frame that limited it to one cut.
Sorry,
Cycle.
I possibly misunderstood the question. all regional council consents have a duration on them. So the maximum term that could be granted would be 35 years. So it would be not a perpetual situation anyway.
Sorry, and I think I have been totally misunderstood. What I want to know, because of the cumulative effects that you can get from various people doing this all together, is whether you can have a rule that allows you to only have one cycle, as in plant, have the trees and then cut them, and then you are completely reassessed. And that was my original question. Because it's a land use consent, I thought you possibly couldn't, because you then get existing use rights. Because it is really important that we can, if you get an ongoing existing use right for doing this, then you can't do the cumulative effects, which we've been talking, that Karen was talking about.
Once you cut it down, then you're in the use control. Sorry, we're just figuring it out. I think now I understand what you're saying is, yeah, essentially.
Your consent is for your harvest cycle. Well, yeah,
one cycle.
One cycle, yeah.
But once you cut those trees down with your consent, you're then replanting and you're in the NES framework.
The question was, can you get out of that existing use cycle and have 1 year, 1 term land use consent?
We'd probably need to
not have to have the NES apply.
The clause 3 version that we went out with for engagement, it also required a consent for replanting as a restricted discretionary activity. So that would certainly have given the opportunity to revisit things at the time of replanting. That received considerable pushback and concern from the forest sector, including about ETS obligations and other uncertainties that they would have. So yeah, just flagging that it came back with a lot of pushback. But that was the clause 3 version, did enable that revisiting of the appropriateness or the cumulative effects at the time of replanting.
I think we could do what you're suggesting, but we would require that replanting of forests established after a certain date would also require consent. So then you're going back into that consenting for replanting if you did want it.
Well, I think it would be only deforestation. And the reason I'm putting it is we actually have the paucity of information we have on water yield issues in some EPMUs, and the fact that we're not going to have really particular EPMU data, it really concerns me that in the Kakanui, for example, I mean, we've been out there and the water yield there is just scary to think what's going to happen there. I think from what we saw and what we heard, maybe I got it wrong, but I just would hate to see them having an existing use. I mean, it's too late now, but and so that then puts people on notice that they may have an ETS issue.
We can go back to the clause 3 version, but the direction was that it didn't land particularly well.
You know, it's good. It's good that we're having the discussion and keep going. I think it's probably good that we keep going and get everybody's views and come back if we can. So I've got quite a list here. Richard, are you?
I'm all good.
You're all good? I've got Gary, Andrew, Kate, Brian, Kevin.
So at the moment, harvesting is a permitted activity under the NESCF. And so they have harvest plans they have to do under their own regulations. At the moment, it's a permitted activity with us. And we're looking under our new plan to move it to a controlled activity. So they will have to get a consent, but under a controlled activity, we have to grant the consent, but we impose conditions.
Yeah.
What happens if those conditions are unmanageable?
So a controlled activity condition, the conditions can only be over the matters of control, but we can't decline the consent. So
what are we achieving by?
So you'd be managing the effects of the activity. So you outline what the effects, so the rule would seek to manage the effects of the activity. So looking to manage this, your sediment, your runoff, your bare ground cover, whatever it was, you'd have conditions on your controlled activity around that in the rule, and then you'd get conditions that implemented those.
Do we have justification to impose that under our new plan now? That issues are being created now? That then isn't covered under the permitted activity rules?
The two technical memoranda attached, particularly the compliance one, in my view, indicates that it's justified to have a controlled activity rule to impose, where needed, some extra requirements above the National Environmental Standard.
But looking at those examples, the photos that were there, one shows a wet road, one shows a dry road. We say we really like the dry road and we don't like the wet road. The culverts looked clear. You could see the ravelling on the batters. We're saying one road is compacted battered banks, we're saying the other one isn't. But I think the two would look quite the same if they were both taken on dry days. And so it looked as though we were trying to create consent issues potentially for activities that when it's raining, of course, it's going to look worse, but when it's not raining, it won't. But I guess my main fear is that are we going to capture forests that suddenly need a harvest consent and suddenly become unharvestable because the conditions of that consent may not be able to be met by the sector?
No, I don't anticipate that to happen, and that's the idea of the consent process. Joe's just going to speak to it though.
Yeah, and also we can't issue a consent with conditions that will frustrate the use of that consent as well. So as Anita said, we are very aware of the importance of good consent conditions.
So then why do we need it at all?
So we want to manage the effects of the activity. And that's the direction from council. That's the direction from this table. But that's why it's here again, having another conversation.
Because I think the sector are indicating that that can be managed under the permitted activity rules that we can also monitor and enforce.
So we've got limited ability to charge for that monitoring, and our internal feedback is that we don't have sufficient ability to manage that activity under the NESCF at the moment, hence why the rule is being proposed.
But if it's only about charging for our time, aren't we more concerned about the actual effects?
No, so we don't have enough tools to manage the effects. We don't at the moment under the NESCF, we don't have enough tools to manage the effects, was the second part of that statement, hence why we've proposed the rule. But it's your plan and it's your direction.
Can we have example? Can you give us an example of that? Of what you can't manage, or what the tool is? Sorry to throw that in.
No, that's all right. We just we might just need to pause and get one of the compliance team.
Absolutely. Yeah.
Available.
So what we just
We can charge under the permitted activity thing it says on here.
One example that we've discussed with at least one foresting party is under the NSCF there's no real restriction around harvest turnaround, so from harvest to planting. And so one of the things that will be covered by this consent is through your harvest consent, you go through, well, you define what your processes for harvesting and how you're going to undertake that. You also specify timeframes within which you replanted and the activities you'd undertake when you were planting. Now, at the moment, you under the NSCF, you could get away with quite a few years of not replanting and managing that land by just helicopter spraying with glyphosate, that kind of activity. And that does have a sustained long-term impact on sediment yield on a block of land. So that would be the kind of thing that you'd be talking about managing. It's one example, but there are more from the consent compliance team as well.
Can I ask another question?
Yeah,
Does that then create some unintended consequences? That I mean, how in depth has this been explored with the sector around? They may have just reasons why they have X number of years to either allow slash to break down, to allow a certain level of cover regeneration before they replant. manage weeds over a certain period. Has there been enough undertaken with the sector to fully understand?
Yeah, we did discuss that, and we discussed how good practice might look like, broadcasting a cover crop in the period of time that you're waiting for your slash to break down, and then undertake another activity rather than just blanket spraying 2 to 3 times a year. So that kind of thing would be covered by consent. At the moment, you can get away with just leaving the land as bare for quite a substantial period of time.
Thank you, Tom. We'll move on to Henry.
Thank you.
Thank you. Just on that last topic, potentially climatic conditions could impact as well. You may not want to plant in the middle of a drought if you had, you know, farming season from May to October. You've had no rain for 12 months, so yeah. My question relates to the setback, which isn't defined. If it's okay, sorry. If it's more than the NES-CF in terms of setback, so my understanding is NES-CF is over a 3 metre wide waterway, it's a 10 metre setback. If it's under 3 metre wide waterway, it's 5 metre setback. So I'm concerned that if through our process that a forest that had been registered for ETS is felled, and then they need to have a greater setback than the NES-CF, what liability, and this was raised through the forestry sector, the Southern Wood Council, and I think they quoted $46,000 a hectare potentially, and then in another quote it was going to cost the region up to $400 million or something along those lines. So I'm concerned about the liability to this council if we were to create a rule that would not allow that forest to be planted back to its existing setback because it's registered for ETS and would be required for that to happen. Does that make sense?
Yep. We have recommended a change so that on replanting, only the NES-CF setbacks and other NES-CF requirements would apply on replanting. That's our recommended position, which I think addresses that concern of the industry. However, I'm aware that around the table there are different views on that. So on the where the ability to replant could be managed or not. So yeah, in terms of that industry concern, I think we've addressed that in the recommendation before you. I'm aware it's not settled.
Okay, thank you. So the other query I had was when it talks about establishment of native vegetation or leaving native vegetation, you know, beyond the 10 metre strip. If there is no native vegetation, but they are required to have a greater strip than 10 metres, what is the expectation for that additional meterage to be managed? Is it to be controlled from a noxious weed perspective? Is it to be planted in natives? What are the expectations for that strip?
Again, that's going to be a case by case thing that depends on how the forestry owner wants to manage it to an extent. Certainly those setbacks can be reduced to 10 metres if there is predominantly Indigenous vegetation or Indigenous vegetation was planted. And the management plans that they would submit would be addressing that as well.
And can I just probably a question for Joe? Currently a harvesting management plan is required to be submitted to the regional council if a forester was going to remove a block of trees. Is that correct?
So that'll depend on the requirements of the NES-CF. So there is a requirement for them to supply management plans to us as part of permitted activity statuses. So yes, I think that's correct. I'll just need to check the regulation itself.
Yeah, that's-
Thank you, Andrew. I've got Kate, Brian, Kevin.
You had one you were going to ask yourself before. It wasn't the same as Kevin's, if you want to.
I didn't know, you just got confused.
Yeah,
I know,
yeah.
my question got answered in the discussions.
Okay. Mine carries on about the non-Indigenous and Indigenous, and there's a few things that I think we could be, and maybe they're non-regulatory ones, but at a catchment scale, both, I don't know how I define an Indigenous and a non-Indigenous. If you've got one but gorse bush in there, does it stop it becoming Indigenous? I don't know. And I think it's a really fraught one. But what I think we could be doing is driving good practice and giving the people a good idea of what good looks like. And we don't seem to use that as a tool. And maybe there's good reason for it. Two things. One is biomass. We've got an energy deficiency, and we've got a huge asset in the forestries, potentially. And nothing drives us to look at that biomass resource really well. And I know it's often because it's depends where it's located compared to other businesses and everything. But if we had things in there that drove you to have a look at a harvesting mechanism that increased your biomass returns, then your opportunity to get rid of the slash problem, again, to where the other day burning it all off, and that's fine, but it's not particularly green, is it? And then the other one on that count was access. So we, I don't know if you have to have 10 metres setback, whether that includes a 2 metre wide cycleway, walkway, or whatever that goes through there, because it connects into at a catchment scale to things. And again, they're just unknowns, and I don't think we're driving what really good could look like. And it, could be going to a lake up at the top of the forest or something like that. Does it make sense? I just don't know that we're directive enough that we could be using it as a non-regulatory best behaviour management practice stuff. Or am I just dreaming?
Lots of those things are just not within our functions, so that you're not going to see them in the plan. A cycle trail is not within our function.
Biomass energy surely is.
But the cycle trail part.
Well, it's more than walkways, and there may be the access to the Mahingakai sites and stuff like that, which I think actually is in our purview if we wanted it to be. Right.
Thank you, Kate. Brian?
Yeah, cool, thank you. Just so I got this right, on that table on page 1, where it says harvest, no change. Are we saying it's controlled activity because it was previously permitted? When it says no change, it's going to be controlled.
Yeah.
And when we're saying
Sorry, this is the clause 3 version. It did have a controlled activity consent required for harvest, and we are not recommending any change. The earlier discussion on permitted is that currently, under the current rules of the existing plan, it's a permitted activity.
Yeah, so staff is recommending controlled.
Yeah, that's correct.
And under a new forest, staff are recommending a discretionary consent.
Yes, I think there is quite a potential to have a restricted discretionary, but whether it's restricted discretionary or discretionary, I think it would cover essentially the same ground.
Okay, and if you're replanting, I was also a little bit confused about your time periods because you said it was up to a maximum of 35 years. But if you're replanting, you haven't got a consent, yeah? It's probably already expired.
Yes, and in that situation, we would be, as it says there, reliance on the NES to control that is what we're recommending.
Yeah. Okay. So there's going to be, where you said 35 years, if that's the situation, that it's going to lapse, isn't it, in terms of a consenting regime? If you're in your second rotation, you're going to lapse. You're under the NESCF, so there won't be a consent. You'll be under that, but you'll need something to harvest.
yes, you will need a separate consent for harvest. That's correct.
Yeah, okay. So, yeah, so okay, thank you. Thank you.
So that comes back to what my question was originally, if you get a consent for a new planting, and the consent may include large setback areas, I guess, they say 20-meter setbacks. And then your fill forest does its time, it's cut down, and the consent basically elapses. Does that then mean that that forest can go to the NESCF setbacks? Or
Under the wording we've got at the moment, yes, it could. My assumption here, and it may be incorrect, is that if you were planting a forest now with the setbacks that would be required under this, when you got a new consent here, in 30 years when you go to replant it, I imagine the regulatory framework is going to be different. And that's the assumption I'd have to say. So this is more, to be honest, for someone who has a mature forest that's going to be harvesting in the next decade, that going back to the NESCF framework, in my view, they're far less likely to have this kind of setback or modern requirements that would be under for a new forest now.
thank you. We're up on Kevin and then Elliot.
Yeah. Permitted to controlled, it does say on paragraph 31 that note that under the NESCF, ORC can charge for monitoring certain permitted activities. But your major concern was not so much around the charging, was what tools you could then use to enforce where you see a hiccup. Is that what I'm hearing?
Yeah, the feedback from the compliance team is that they wanted to have an ability to have oversight over that part of the activity, and a controlled activity is the lowest level of consent that enables that oversight.
Yeah.
So that's the most straightforward way we can do it. When the feedback we're getting is reliance on NESCF is not enough, we're still seeing the issues in terms of water quality.
Yeah, right. So, and just going back to what Lloyd has just talked about. So an existing forest, we're recommending that we can replant under the existing NESCF setbacks. So if they're at the moment, they're at what they are, they can replant at that. So the issue I do have was, so we've just given a new forest today on the banks of the Pomahaka, and it was all salty land and trodden probably by Lloyd's dairy cows, but we've said, well, we need 20-meter setbacks here to ensure there's no sediment erosion. And so in 30 years' time, Lloyd gets out his old chainsaw and cuts that down. Are we then saying that even though we had a tougher consenting regime applicable to the land type, that we can now plant up to the 10-meter one?
Yeah, that was kind of.
Yeah, so to me would be a bit of a, that's a backward step. So I just wonder where I'm just saying if a new.
It would be a relatively easy addition for replanting to have no reduction in an existing setback.
Yeah,
that would be a solution that you would want. Can certainly put that in.
See what I'm saying? Because we've done all the good work, and I would think foresters, when they come in with their plans for consents, they will have done and have the homework done on those types of lands to prove that yes, we can plant to a certain space, and where they've got 20 meters, well, it wouldn't be their intent to plant it within that next time round. So I think we need something there, really. Does that make sense?
I think Rich might have a follow-up.
Oh.
Yeah, sorry.
Follow-up question.
It kind of makes sense apart from what Andrew Noon's question about whether you can spray, right? But spray that whole zone, or you plan to plant it out in native bush, you know, it's quite different what your margin actually has in it. So you might want to retain the ability for, if you're a forester, you probably push back quite hard on this because the nature of that zone would be quite different. Yeah,
So,
maybe. I don't know.
So
But I hear what you're saying.
could I just make a comment back to that? So therefore, if in 30 years' time, when Lloyd gets his chainsaw out and cuts them down, if in fact he wants to change it from what's a grass regime there at the moment into a native planting, you would then look for an alteration to your consent or a change to your consent. But that is that what you'd need to do if we put it in?
I think you would, but that's
Yeah.
sort of, it's not a great incentive, right? If it's permitted activity to carry on doing what you're doing and you want to do something better, so you need a consent, like. So I think we probably just need to look at, I totally understand what the issue is now, but I don't have the solution. And
No, that's
I
right.
think we know now what we need to think about and figure out.
Yep.
So yeah, we
Cool.
can come back on this.
We'll just, I reckon Lloyd would be really happy if he can lift the chainsaw in 30 years' time. Yeah,
I don't know if you could do one now, mate.
We've sort of already traversed this, but I just want to, I guess, confirm or clarify in terms of what can happen in that setback. Are there any restrictions over and above what would already be restricted that far away from a water body in terms of what you can do in the setback? You know, it's just something like a cycle path or something.
I don't know, Matthew. I'm not that familiar with the NES, and that was what I wanted to check before answering this, but I don't know if you have the answer.
No, I think the NES is relatively silent on what happens in that setback, other than that it's not used for commercial forestry. But happy to have a look. There's been another question on the NES, so I'm happy to have a look at that and come back on that.
and that could well come back to good practices or good management practices or good environmental practices that would be acceptable, yeah, community type stuff.
Catchment scale.
Thank you, Brian.
So we've talked about all these issues, just as a matter of interest, you know, the forestry sector was very animated. What will their view be now in terms of what's proposed? Have we, you know, come to a common understanding, or is there a gap? Thank you.
That's a good one.
I don't think we've reached a common understanding.
We wanted to bring it to you before we went to them with kind of the direction we're heading, so we haven't talked to them about it as yet, but.
And just to yeah, so there's a question this morning, I think it might have been from Gary around have forestry involved in clause 3, and we said no, because we've got to go through this process first, and then there's an opportunity, as there has been for other clause 3 parties, for them to come in and have a further conversation. So once there's direction from the table and that can be packaged up, then we'll make them aware of what the outcome is in terms of our response to their clause 3. I don't think we shouldn't be expecting alignment to complete alignment, and we've got to remember there's other parties to the land and water plan and the clause 3 consultation that have very different views. So we're never going to get alignment right across the spectrum. The role is to assess what we consider the most appropriate, mechanisms are for the controls we want to put in place. Have a good discussion with forestry and agree on what we can agree on, and based on the evidence we've got and that they've presented through clause 3. But there will still be some differences of opinion, and there's further steps in the process that parties can take to work through those. So that's the process from here, which will include reaching out to them, and then may include a subsequent conversation. But I guess just flagging that there are other things to consider, and going for full alignment shouldn't be the aim of this process, because I don't think it can be achieved. And also, if you get full alignment with one party, you will not have alignment with numbers of others. And so, there's a balance that's to be struck as well.
Okay,
Sorry, I should have asked this question earlier, but I couldn't decipher my notes. So now I understand what I was trying to ask about the Indigenous and non-Indigenous plants. And I presume the actual purpose is about sedimentation or maybe even temperature of water. In which case, I think there are smarter ways of resolving that potentially if you're doing a, and that there's a lot of Indigenous plants that I could probably plant and they won't have a good effect on that. And I think we should be really clear about what it is we are trying to fix by having that setback. Surely, I mean, yeah, maybe I'm wrong about my Indigenous plants, but I would have think there's quite a few that don't necessarily capture sediment as well as others.
I think what you're saying, Kate, is plants suitable for riparian management or protection.
Yeah, it could be that, but you know, in certain areas it may be that you want taller things on a north side to do temperature and, you know, do all those sort of things. And on the other side, you may actually want the grasses, which don't look, I don't know, Karen is obviously more intelligent in the space, which wouldn't be hard than me, but I think we actually have to be really clear about the objectives and the policies that we give, and each site will be a case by case, as you say, but we could be really doing, yeah. I don't know, it's not an easy rule.
Thank you, Kate. Karen?
No, I don't know much at all, Kate, but I do know that it's not probably within our purview to do what would be ideal, because the ideal is to reach into the knowledge of the local kaumata who can talk about what was actually Indigenous per site virtually or area historically. And so you're right that not all Indigenous plants will do the same thing because they're much more microclimate specific. But we've got no control over that, much as that would be an ideal state. That would be very ideal because it would deal with the sediment properly. But we just don't have the control. But that's really where the knowledge base sits.
Well, and it's consistent. I'm going to go back to the way the point was earlier. If we don't do this FMU specific, then we may get some really unintended consequences. And we've got dry areas and we've got wet areas, and the responses there will be quite different. And we could be doing some really neat ecosystem stuff, giving us guidance on that. But if we just do it blandly right across the whole Otago, I think that the responses may forget or may miss those really good opportunities.
I mean, one option is that we just have a single setback, which is either 10 metres or 20 metres, and forget about if it's got vegetation or not. I think the reason that was there in the first place was from a direction that the council wanted to promote, you know, the planting of Indigenous vegetation, and that was a way that we saw that we could do that. But, you know, if it's going to cause more problems than it's solving, then we don't have to have it. So.
Sweet. I'm really keen for everybody to have a say, so just people who haven't had a say, do they feel you got?
Oh, sorry.
I'm happy to have a say. I mean, I did have questions, but they have been answered through all this. Yeah, look, listening to this, I mean, I'm happy with this proposed direction. It seems to me, and I'm convinced there are good reasons for asking for a discretionary consent at new forestry planting and a consent again at harvesting, so we can have that extra controls. I guess I think, yeah, lower risks in some reason and some ways, and some of those things already taken into account earlier when it comes to replanting. So I can see the logic of not requiring it and relying on the NS CF at that point. So look, I'm happy to go to continue, and particularly knowing there is likely to be further discussion with the clause 3 parties on this, but to proceed in the direction we're going in for now. Thanks.
Thank you,
Just a level of comfort, really. I am aware that the foresters' concerns seem dramatic in terms of the impact of setbacks, and so the proposal here to go with the NESCF, what difference in terms of the claims that the foresters were making anyway, that they was going to have on their forestry, their plantations. It seemed they're talking hundreds of millions, I think, in terms of the effects. What is the difference? What is the, is there a degree of difference by relying on the National Environment Scheme?
Sorry.
Sorry, I'm looking at Matthew, but
Oh,
thinking I'm.
Apologies, I was looking at you. The council has looked into that issue of ETS liabilities, and it would be fair to say that staff don't necessarily agree with the liability situation that's spelt out by the foresters, but there are areas of grey in that. So yeah, that effectively the recommendation does dispose with that issue.
Is it relying on the safety of the national environmental standards, or taking the liability away from the council? Is that...
Or any of that risk, yes.
So pretty much, I think, just from my understanding, so basically if the existing forestry continues under its current regime, so it doesn't have any impact on those forests, it would only be new planting that might be, if we have consents for new planting, there may be some different criteria on individual plantings depending on where they're located and the potential environmental impact they may have. So it gives us a wee bit more control ability to have a say around ensuring the protection of the environment. I still quite haven't got my head completely around the harvesting consent, but I think that's the harvesting consent for me. So the proposal is to have a control consent, which is pretty much specific to the harvesting and actions per se, or how they go about harvesting and managing the plant trees. Is that correct? So I'm trying to recognize what impulse that would have on the industry beyond what would be normal or good practice, I guess.
In my view, and having and had that compliance information back, the idea of a controlled activity consent, some conditions might be imposed on it that required additional mitigations, additional protection against sediment losses, possibly if there was a risky situation larger than or more extensive sediment protection than what the National Environmental Standard would require. Those kinds of site-specific things that might go beyond what the NES requires would be imposed as conditions for that particular harvest.
And again, it will relate to the particular site. So, if there's a site that's low risk, then it will have very few conditions. Whereas if there's a high risk site that needs to manage, a particular critical source area, then, it'll have a condition around that. So it allows it to be.
Probably don't see that as being unreasonable. Yeah. Alexa, you got any comments? Maybe not. Michael, are you there?
I've got no further comments, thanks.
Oh, thank you, Alexa. Yeah.
Good.
Awesome. Garrett?
Yeah, sorry to labour that point, but I actually see that as fraught with risk around an interpretation has to be made as to what those risks are when you apply for that consent. And I think the sector is then going to have to justify and live with conditions that may be overly onerous it would be really good to get an understanding from the sector, just what they think that situation will be. Thank you.
Thanks, Gary. Brian?
Yeah, just following on from Gary, because Gary did raise the point earlier on, that what the difference is between the permitted and the controlled activity. Well, I've actually been involved in harvesting and forestry under the permitted regime. We had to get a management plan of which various obligations were expected and audited. That was without a consent, but that was still with the ORC process. So I'm not involved in forestry now, but I'm struggling to understand the answer to Gary's original question about why the status has been elevated from permitted to controlled and what the benefits are. Bearing in mind that as a council, we're trying to do as much as we possibly can to go in the opposite direction and still do the best for the environment.
Thought it was the one time you agreed with me, and
Exactly.
it was off
So
the whole time.
I couldn't let it go.
First time
Gary.
No, I heard it.
Enough.
It was magic.
I couldn't let it go. Yeah.
No, it's
Start
very
again.
good. Start
Yeah,
again.
yeah.
15th of May will be a day each and there.
Write it down.
So we have any other discussions? Because at the end of the day, I think we're seeking some kind of direction, feeling from the table around pretty much the three areas. So basically, the proposed discretionary consent and planting time. Go back to the wee sheet. The discretionary consent and planting time. Consent and planting time, and then the harvesting. What was the third one? Harvesting consent.
Replanting.
In the replanting at the NESCF.
Correct.
So, yeah.
The only thing I'm struggling with is the real rationale behind the bullet point for the rationale behind controlled and permitted. So really an understanding of the tools that it's going to, not now, but I mean the tools that's actually going to give you over and above permitted with the right scope of things really. So I sort of understand it, but I think we need to have a bang, bang, bang and weigh that up really. And you've probably done that, but that's where I'm, well, the rest seems pretty good to me really.
I've probably still got the odd question. It's stuff that's come up in the discussion, and one is around if you do a consent to plant forestry, and then you're going to have a pathway whereby you pathway that reverts back to the NES after the first harvesting round. Why do we do the consent right at the very beginning? But I do understand the need to front foot it right at the beginning. The other one, and that leads into your duration of your consent. So when does your consent finish effectively, and the next process takes over? And then I'll probably still just probably a little bit around what Gary and Ryan were talking about around the harvesting. One is, what is the difference between like a well-controlled permitted activity and like a well-monitored and enforced permitted activity, as opposed to get a controlled consent that's pretty much likely to say just reinforce the permitted activity. That makes sense. Sorry, I went a wee bit around in circles, but yeah. It's just we've got to get, we just want to, we just got to make sure, like, I don't have any issues in being quite stringent around protecting the environment. So like, I'd be more than happy if you had a plan that says, there's a duration and consents. I just can't, like if you had, if you get a consent for setbacks I'd expect that those setbacks would continue for the duration of the time the period was in that land use, but I don't think that's how it works.
Yeah, we can do that, and we've got that noted down as a thing to look into, because I think that is something that we hadn't kind of quite nailed, so that was definitely something we're going to. I might just have a crack at answering that question about why doing a controlled activity. And I think it kind of comes back to that point again about if you, with a permitted activity regime, you have to have like one rule that applies across. And so it has to be like, it's really hard to kind of make it flexible enough. And so the idea of having a controlled activity means we can look at the site and look at, you know, what are the risks at that particular place and how do they need to be managed. As I said before, if they're a low risk site, it'll just, you know, sail through. And so, you know, it's, but if there are big risks that need to be managed, then they can be, and we have control over how those are managed.
That's why you have a site-specific management plan.
Yeah. I'm also very, like in my mind, a change of land use from pastoral agriculture to forestry is a significant change in land use. And it's pretty much non-reversible, you know, without major effort. But so I sort of, you know, sort of like on we got big trucks.
Harvesting too is a very technical, specific to the industry activity that they have. They're always upgrading how they do it. We would have to have a level of expertise to be able to make those judgment calls over and above them, and then be able to back it. Anyway.
The challenge with the harvest management plan, and I'll just confirm this 100%, but my understanding is we receive them, but we've got no ability to influence, control, or do anything with them. We receive them, and the controlled activity gives us that ability so that we don't get the sediment and water when that activity happens.
Okay,
I'll just
okay.
confirm that, but that is
Okay,
what I
well,
think.
if that's the answer, that's fair enough. That wasn't my experience. Fair gold was put to me, but.
Thanks. Okay.
Sorry, going back, there is a paragraph and I couldn't find it before, about water yield. But it doesn't, and it surprisingly doesn't talk about Alan Mark's work, I don't think. Maybe his is a blended one, but Alan Mark did a lot of work on forestry, compared to tussock and anything, and conversion to water yield. But anyway, that work isn't referenced. It is a big topic, but I don't think there's anything in there. And going back to that previous discussion is, why don't we have an alternative pathway which says that if you're a licensed harvester, you can do it because you have met a certain, I mean, in theory, if practices keep on changing, which they will do, and you could have people who are licensed to carry on, licensed or authorised, and they can be ticked off if they don't do it well, then that is a huge step forward for them as a business.
Just, is there a licensing regime?
No, but I mean, the question is, can you do one? I mean,
FSC certification.
yeah. So, I mean, that's what we've looked at in other things. I know in other places there are licensed, you know, board drillers or licensed, I think even gravel extraction. We don't have to have it fundamentally there now. We can work out how we can deliver it. But that means that you're keeping on top of best practice at the time. And we're looking at alternative pathways for farming. Why wouldn't we look at it also for forestry? The same.
It would need to be permitted and it would need to be certain, so we would need to have the framework in place. We wouldn't, but we'll add it to the list of things to look at.
Could I also just say that under similar frameworks in a couple of other places in the country, I know that harvesters get a global consent so that they can harvest, you know, harvesting firm can harvest anywhere based on the standards and criteria that they've got in their global consent. And some of those have been useful, as I understand it, elsewhere in the country, so that these rules wouldn't prevent that happening.
Thank you. Good answer.
I think we have any other comments?
a couple of things.
I just like really support the controlled activity at harvesting time, but in the reports, I haven't seen comment on sediment into the coast. It talks about the estuarine issues. But sediment into the coastal environment is quite a serious issue as well. Is it a factor?
Yeah, I think you're right. I think the memo was relatively silent on that. However, our coastal scientists did input to that, and I think it's I think he allowed it as implied that anything getting into the estuaries was also likely to be impacting the coast. And we actually help get studies and that sort of thing going on at the moment to try and quantify the impact of that.
Thanks.
Sorry, just one comment to that. So are we comfortable that we have got the appropriate protection in our wording for the coastal area? If not, we'll probably.
So if it's directly into the coastal area, it's covered by the coast plan.
Yeah.
But in terms of the estuary flowing through into the coast, I think that will be done by, like it's all.
Yeah, our general thinking was that estuaries are typically your most sensitive receiving in the body, and rules and frameworks that look after those water bodies will inherently look after the coast to an appropriate extent.
So your establishment consent and your harvesting consent would also protect those spots as well, I would assume. Thank you.
Well, I'm going to kick it off. I think I'm probably where I'm sitting right now is I probably support having consent for the land use change part, but I just need a wee bit more clarification around the duration of the consent. I'm happy to support the I'm happy to support that the second part that around the replanting. So it's basically the one for existing forests that are under their existing regime. You can harvest them and replant them under their existing regime. So that takes away, the that sort of speaks to the investment of the people have got in their forests now, because I don't think it would be wise to undermine that. And I'm also happy enough with the control consent and harvesting as well. And I preface this a little bit on consents can be really difficult, and they can be really quite straightforward. So I think the challenge is that we have straightforward consenting regimes that if you're applying for consent, that if you're doing what's perceived to be good practice, and that's good practice is different on one site to the other site, which may or may not be linked to the bottom line permitted activity rule. But if people are getting consent, that are following good practice at the time, that it's going to minimise the impact on the environment, I'm happy for that to go ahead. So that's my position. So basically, I guess I'm agreeing, but just with a couple of a wee bit more detail around some of that other stuff, just to make sure that all the loose ends are tied up. So that's my position. If anybody else prepared to. Andrew?
I don't really disagree with what you said, but the only thing I would say with that data that we received from compliance, I think we should just note that out of the 230 odd harvest management plans or whatever, there's only approximately half of 130 or whatever that were monitored. And I appreciate the comment was made, lack of resource and that sort of thing. But if that's not happening, that's not good practice from our perspective, is what I'm saying. If the issue, and we saw the photographs, if there are issues there, were the photographs that were shown in those particular sites, were they some of the sites that perhaps haven't been monitored. I don't know. I'm not suggesting they were, but it's a question. So yeah, that would be my thought, where, you know, we're possibly not fully using the tools that we've got in our toolbox now. That's my point.
Thank you, Andrew. Brian?
I was just going to once again express my uneasiness around the fact that if we replant, if somebody replants, they do it via the NES forestry. Whereas if you do a new one, you have to apply for a discretionary consent. And when this whole process kicked off months and months ago, you know, it was a 50-metre setback, which is just one of the attributes. But I haven't been able to get an understanding of how much that's moved. It's obviously moved between 10 and 20 for less than 10 hectares. But other than, so before I throw my hand in the air, I'd like to have a better feel of just where that understanding has moved to in terms, because that's important. Thank you.
Thank you, Brian. Anybody else's? Karen?
Yeah, for me, I'm not convinced that we gain much by adding a controlled activity other than added cost and added red tape and regulation to the sector, which is a very specialised sector. So I'm not a fan of adding that stage. I think the NESCF should be the guideline, and we work to that. If other groups are determined to see standards over and above that, then they bring to the table their issues and justification through the notification process. Thank you.
Thanks, Karen.
Can I ask a question now? Is it too late?
I'm comparing, this may be an important sector. It may be a very specific sector. It's just another land use for me. And I'm not really seeing it much distinguished from farming. It is just another land use, and we are looking at what the effects and risks are. And so when they're planting, the biggest risk is actually this spraying they do. And we've talked about spraying for farming. What is it with spraying for forestry? Are they allowed to use aerial sprays anywhere? Is that restricted in the same way? Because I just want to make sure we've got consistency.
It's more than just
Yeah,
spraying.
it is. So that'll be covered by the other discharges, part of the thing, which we've got some amendments to based
For
on
next
the
week.
RPS.
Yeah, for next week. But there are, I just want to make sure that they are just another consistent land use. I think. I'm looking forward to seeing how that's changed.
Thanks, Kate. Bill?
Yeah, thanks. Look, as I said before, I'm happy with those recommendations as presented in that box, with the exploration of with the replanting, adding something along no reduction to existing setbacks on replanting, which I know you've got noted. That looks a good way to proceed to me. Thanks.
Thank you, Gretchen.
In terms of the initial planting, yeah, I'm still trying to figure out whether or not the setbacks come into effect at planting or actually at harvesting. You would say, no, you're not allowed to chop down trees within a certain distance of the stream, rather than you must plant a certain way at the beginning. So I think it's the harvesting.
No, it's the planting.
For new forest, it would be the planting.
It's the planting.
It would be. Wouldn't be harvesting. That's
I
more
think
important.
for an
Yeah.
existing forest, you look at it at harvest, and for a new forest, you look at it at application time, would be the way I would understand it.
It's been a district council rule for
Yeah.
years, distance from the boundary.
Okay,
Good planting.
do we need an Indigenous forest setback if somebody chooses to go within 10 metres of a stream planting Indigenous vegetation rather than 15 metres? Isn't that good rather than bad? So do we need that? Second one, I think that consenting, although it's probably not as popular, is actually quite useful in terms of a bit of flexibility to the operator as well. Certainty, surety going forward as well. As has been explained, you could get a global one for your whole company if you've got several forests across a region. And we have heard that it is difficult to enforce or regulate the current NES harvest management plans. I don't fully understand that. So like others, I probably need to understand that that definitely was the case. But if it is, then yeah, we need to be ensuring that our waterways are well cared for. We think that this is a critical source area of where sediment can come from. So we want to make sure that that isn't happening because that affects everyone through the catchment. So, and I think, yeah, that the consenting pathway means that that the forester can present to us how they can most efficiently, I suppose, address the issue. And sometimes that's going to be really simple. I think for the bigger companies, actually, it's going to be pretty simple because, as others have said, they have their certification and things like that. For others, it might not be that simple, but they need to have a good think about it through consenting, and I think that's okay. Yeah.
Thank you, Gretchen. Do we have anybody else?
I think the 10 hectares per land area is just one. I think we need to really think about how that, especially if we ever get a resolution on He Waka Eke Noa.
The 10 hectares per land holding, if you've got a substantial farm, it's a pathetic amount of money, it's a pathetic amount. I think it's an annual 10 hectares, or at least a 4 or 5 year hectare, 5 years, 10 hectares. I think, yeah, farm forestry at small scale on large properties is a really good use of land and diversification, and we're just sort of counterintuitively doing it here by making it quite problematic if you're doing it iteratively over time.
So you're suggesting the 10 hectares may could be higher?
No, I think it's the problem is the 10 hectares in land holding. If it was limited, if the rule was permissive for 10 hectares every 4 or 5 years maybe, then that would be different. Because land holdings, they can be vast from 20 hectares to 5,000, you know. Well, if you were, the risk is sediment. If you're planting every year on one landholding, which may be kilometres apart, what is the risk? And that's again with landholding is such a, you know, for some people it's frustrating because they've got title here and a title there and it's one land farm, but it's landholding. You're actually frustrating things when you're actually not dealing with the risks, and that's all.
Thanks, Kate. Kevin?
Yeah, well, I actually think you are dealing with the risk because we're going to apply for a consent to plant it, and we could look at a global consent over the whole property, but we need to identify that risk, and this is just going to be a walk. A lot of people, it will be very much in the right types of land, it will be very much just, I hate saying tick box, but it'll be a very simple process because of the contour of the land and the water bodies and the likes on the land. And once you're into that system, and I dare say if we had a couple of 100 hectares or a couple of 1,000 hectares that were going to be planted out, that would come under one plan over a duration. I am concerned about the consent time frame, and I understand it is between planting and the finish. But if I plant a species that takes more than that 35 years to mature, what happens to that block of land then? So, yeah, if I planted something that takes 45 years, I won't say Douglas fir because I'm not allowed to. But you know what I mean? If there's a species, but
some gums.
yeah, or not even no. I'm just talking an exotic species because that's a different rule frame. Again, just reinforcing what Alan said. You know, stick with the NESCF, but providing that stuff we've given a consent because of the nature of the land that we are having no increase in the land area, something along those lines. And I am Yeah, I'm expecting feedback from this the stage 3 party about us going to a controlled activity, but I think in light of is just not around those big organisations, it's around the whole sector. So I would like to hear their response when if we go the controlled way, what that will be, and I need to come up with something pretty strong that would change me away from that route. But I'm very happy to listen to it. Yeah.
Thank you, Kevin. Anybody else? Well, good. Have you got this? You got a bit of a mixed view there. There's a couple of work ones.
Really useful discussion for us to think about some more things. So, and to come back to you with justification of some places that we might land, and talking to the clause 3 parties again before we come back to you again.
Just in the interim too, I know Joe's just reached out to Tammy just to ensure that they're prepared next Thursday, whenever their regional leadership is, just to brief the table on the current NESCF monitoring program, just to get a good idea about exactly how that operates. So separate to this, but and staff will continue to work on what's been feedback today, but just to make sure there's a good understanding around the table, and we can provide some briefing notes to Karen Edward as well, just to make sure you get the same information, just to understand how that compliance program works. Because there is the permitted activity, controlled activity is a key conversation, but from my experience, permitted activity is you are reacting to things that have already happened. Controlled activity is similar to a farm plan, bringing in management, things like grazing management plans, so that you at least ensure that thinking is happening beforehand and there's a chance to have that conversation. So appreciate, there is a decision to be made there, and the sector will have an opinion on it, which we will test as well. But from a regulator's point of view, permitted activities are always harder to manage because the activity that creates the non-compliance has already happened.
Yeah, thank you. And just from myself, I assume the consenting would be discussions being mainly around setbacks and housing, right? The initial consenting process would include the overall effects of change in land use, like around maybe water flows and socio impacts on the socio-economic impacts of the areas where they're going, that sort of stuff.
It's discretionary, so it can consider anything.
Okay.
Yep, has to be, yep.
Thank you very much. So I think we've come to a conclusion on that one. So thank you everybody for your input, and there's a couple of work ones, as we say, and there's a wee bit, and Tammy will come back to us with a bit more information next week as well. So that's really good. Thank you very much. And I'll see the next, we're due for a break. We were 10 minutes early. I think we could probably just carry on with the next one if that worked.
I think it's a long one.
Oh, it's, I think we might need some.
It takes a long one.
Some take a break.
Overall.
There's only one left, and it's
So
consensus.
come back early.
Yeah. Okay, so we'll come back at we'll just give
Just
10
tell us your
minutes.
decision.
3:05.
Yeah, exactly. We'll go.
Yeah, I think it's very happy. He's going to be able to do what I meant to do.
But you're farming.
Welcome back, everybody. We'll start, we'll reconvene. So our last segment, direction on consent duration. So Felicity's back in the seat by the look of it. So Felicity, you can run us through this one.
Yes, I certainly. Oh, thank you. Yes, I certainly can. This paper is quite short. I won't labour it, but essentially the clause 3 version of the plan reflected the amendments that were made to the RMA last year. Those amendments have now been repealed. So a lot of the clause 3 parties pointed out that it referred to terms and to timeframes that were no longer in the legislation and needed to be revisited. There was a range of views in the clause 3 feedback from parties who thought that the general intent of the policy, which was to have like essentially a maximum cap for consents, unless, and it listed some specific exclusions where a longer duration could be granted. Some parties supported that approach, others didn't. We discussed the pros and cons, I guess, of having a policy on consent duration and what it might and what it should and shouldn't say at a previous workshop. I think it was March. And I've gone back and looked at the original direction provided by councillors in 2022 as well, which is not dissimilar to what was discussed at that workshop about the issues with locking in activities for long periods of time when we're looking for improvements towards achieving targets, and balancing investment needs with duration. So what I have done is looked at, is I guess, gone back to the drawing board with policy and drafted up something which I think reflects more accurately some of the discussions from the last workshop. The main differences, I suppose, are that obviously it removes all of the recommended, sorry, I'm down on the last page in the table. The redrafted policy removes all of the references to the Natural and Built Environment Act and affected resource consents and whatnot that was now repealed. And it provides in one some general matters to consider when setting the duration of a consent, and that links through to the timeframes associated with achieving environmental outcomes and any other methods for phasing out or avoiding over allocation. The second clause essentially sets a maximum duration of either 10 or 15 years and then sets out a series of exclusions from that. So that would be the activities where you could get a longer consent duration. It picks up a lot of the stuff that was in the previous version in terms of nationally significant infrastructure, regionally significant infrastructure, water conveyance for irrigation, stock water, community water supply, hydro, and some requirements so it's either for specific activities in A or it's for any activity, but B, the activity will implement staged improvements to reduce contaminant losses or actual water use in a way that's consistent with achieving the environmental outcomes, or result in flows and levels and take limits being met by the long-term vision timeframes, or otherwise positively contribute towards achieving the environmental outcomes, including by implementing activities identified in an action plan or a catchment action plan. In terms of the 10 or 15 years question, I've gone back and looked at the clause 3 feedback. There were 6 parties that commented specifically on this provision, and 4 of them considered that a 10-year maximum was most appropriate. One of those 4 said 10 or 15. They didn't seem to have a preference between the two. One of the other submitters was of the view that large infrastructure should be granted a 15 to 20-year consent, which I think to a large degree is covered by these exceptions for infrastructure and conveyancing. So I suppose the question is whether this accurately reflects the direction that you gave last time we discussed, and whether there's a preference for either 10 or 15 years, and or whether any other activities or outcomes should be included in that exception.
Thank you very much. And we have questions or comments? Okay, can you kick us off?
I've always had this problem. I cannot understand when you've got a mixed use scheme, whether it's been irrigation and stock water and energy and community water, how you can give different consent periods for something that is inherently so mixed up as an infrastructure that isn't just for one purpose. And I'm really confused because when you go for consent renewals, the investment is really problematic, but then you're going to have different renewal periods potentially.
So generally you would get one consent that covers the whole scheme, and under this policy, any structures, pipes or watercourses used for conveying water for irrigation, stock water, community water supply or hydro, whether it's one of those things individually or whether it's some combination, are all provided in exclusion. So you wouldn't be needing to set different consent durations for them.
Okay, that's quite a marked change, it's great. The other question I had is whether this should be FMU specific, given the lack of timing we have. I mean, some areas we really care. I mean, Cook is easy, seriously, there's not a water shortage issue, appreciating there are some cultural issues there about it, but it's not under the same pressure of allocation. And if we're working, whether we should be looking at an FMU specific timeframes that are quite different.
Yeah, and that was partly what I was getting at in clause 1A, making sure that the duration supports the achievement of those environmental outcomes in the FMUs. So if you're needing to meet an interim target attribute state in the next 6-7 years, would you want to be granting consent for a large discharge that's not making any improvement for a period of 10 years? I don't know. But I think it's a good point though, that you probably could grant longer term consents for some activities in some FMUs more easily than in others.
I just don't think we're not using the FMUs in the way that we should be. And it would just take a lot of the, maybe some of us in dry catchments having to fight the battle alone.
Sorry, thank you. I'd just like to add a little bit here, that's all right. Because I just wonder whether it's FMUs or catchment based. But the long game is probably get back to catchment based gardens.
You know that I'm with you on that, but at the moment we've really only got FMUs, so it's important in here.
Over time, we would likely get there, but we're not there yet.
Yeah. Sorry. Drop on my hand up. I did, for your 1 year number to 10 or 15 years unless. So I assume the maximum is still 35, is that correct?
Yes.
So it would be saying that so that infrastructure stuff would be up to 35.
That's correct.
And the other stuff would be up to that amount. It's not, has to be that length of time.
That's correct. Yep.
Thank you. I saw Andrew and then Gary.
Thanks, Lloyd. I just wonder, with regards to the general theme of the MPSFM was to stop degradation of water quality and obviously improve water quality where necessary over a generation or something. Sorry, I've made it brief, really brief. My point is, a generation, 10 to 15 years doesn't seem like a generation. So I'm just trying to understand why we're not sort of lined up with a sort of a generation or the interpretation of what a generation means in terms of years.
Yes, so the generation aspect comes into play for vision timeframes, which is why some of the visions are out to 2045, 2050, because it's going to take that long to make the improvements. I guess part of the role that consent duration can play in that is making sure that where we've got interim target attribute states that need to be met in the next 15 years, that there are actually opportunities to revisit and change the management of activities to meet those, rather than locking in activities for the whole vision period.
And because you've got the bracket of the 10 and 15, I mean, what is the preference?
Based on the clause 3 feedback, it seems most parties are comfortable with 10.
Yeah, that's your 4-2 split. Oh, sorry, that's your sort of 4-2 split based on that.
Yeah, that's right, yeah.
Okay. Yeah, sorry, you mentioned that.
Thanks, Kevin, we've got Gary, then Kate.
Could I just ask one on that, what Andrew's just said was, you had a 4-2 split, but of that 4-2, who were water users and who weren't? If you know what I mean.
Yep. 2 of the 4 were water users. I mean, they're all water users, but 2 of them use water for commercial purposes, I suppose would be the distinction.
Yeah.
I think there was one that was either or on the 4 as well. Yep. Yeah. Gary.
Thanks. So just in reading 2 in the table on the right-hand side, so what we've moved to, B, I'm just reading this correctly, aren't I, that B are not conditions of A. You can have what we've defined under A in isolation to B.
That's correct.
Okay, thank you.
Thanks, Gary. Kate.
Did you move on? He didn't stand up this way.
Oh, sorry, Elliot, you can jump in there.
I just first had a quick question because we're talking about the 35-year backstop. I just want to confirm, is that for all consents or is that just for the discharge and water permit stuff? Because the background starts.
Yes. It is for discharge permits and water permits. Land use consents are unlimited, although I don't think I've ever seen a consent with an unlimited duration. I mean, even those land use consents tend to have a duration.
But if someone did meet either A or B in that criteria under 2 in the table, and it was a land use consent, they could have any number of years in theory.
That's correct, yeah.
I think given the feedback, 10 seems like a pretty appropriate year in my mind. And then I was going to ask the same question as Gary, and also suggest that B actually seems quite broad to me, and I wonder how restrictive it would be if or at the end of A2 was changed to and.
Yeah. Is that or and?
Yeah, so it's the difference between A and B is or. So either you're a specific type of activity that's listed in A, or you're any activity, but you're doing the things in B.
You're doing right.
Because B seems pretty, I don't know, I don't want to say easy to me, but it seems like quite a broad and open thing.
Yeah.
We wouldn't necessarily want that.
And I think that was.
I think we'd only want to apply to the ones that would already meet A as well, but that's fine.
And I think my reason for drafting it that way was really that if you're taking water from a catchment that's not over allocated and you're complying with the minimum flows and with the take limit, and that resource is not under pressure, then I'm not sure there would be a reason to limit it only to 10 years. You could well have a longer duration without being problematic. It's really the catchments or the FMUs where there are pressures, and we're trying to improve things when the duration comes into play more strongly, I think.
Right.
Yeah, I'm just wondering, in that example, you could sort of pretty easily meet if you were just improving the way you were doing things, then you could get yourself a longer.
That
No.
A2 is construction, replacement or upgrade of the structures. Or the infrastructure used for conveying the water.
Building.
Yeah.
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 Cool, thanks.
Next, I've got Katie and Brian.
Plus, I know that the RPS talked about over allocation, and I got the feeling that it actually laid it down as an issue. And I actually haven't read that section for ages, so